Thank you. I'll say that again then. So welcome everybody. We're here today to consider an application for the variation of the premises licence in respect of the Millet Road. If everybody could put their phones to silent, and fire exits are actually that door there and that door there, and we meet in the car park. I'll just run briefly through what will happen today. I'll introduce the panel, which is the three of us, and then we'll ask some people to introduce themselves. I won't ask everybody to introduce themselves, or we could be here all morning. But if when you're speaking, you could just say who you are before you speak. Though I will ask that person to come up, so hopefully it's the same person as I ask. Okay, so what will happen is we'll go through the various bodies. The licensing officer will speak, the applicant will speak, responsible authorities will speak, anybody else who's made a submission and wishes to speak will speak. After each of them have spoken, there'll be an opportunity to ask them questions. We'll start off then. My name is Simon Carswell. I'm chairing this subcommittee. I'm a Somerset councillor for Street.
My name's Mark. It's over there. Hello, I'm Marcus Kravis. I'm a councillor for Dunster Division, which is in West Somerset.
Good morning to you all. My name's Hugh Davis. I'm a Somerset councillor for Watchet and all the way to Hinkley Point, that area. That's my area. Thank you.
Leslie.
Yes, thank you, Chair. My name is Leslie Dolan. I'm the Principal Lawyer and Practice Manager for Somerset Council, and I'm also the Deputy Monitoring Officer. And this morning, my role here is to provide legal advice and support to the subcommittee members. Thank you.
My name is Debbie Widows. I'm the Democratic Services Officer. I'm here to minute the meeting and help anybody with any queries.
Jack.
Good morning. My name is Jack Godley. I'm the licensing lead at Somerset Council.
Good morning. My name is Phil Wake and I'm the licensing officer for Somerset Council.
Good morning. Dominic Rowley, Tenant Operations Manager for Buckham Brewery.
Good morning. Tim Shield from John Gaunton Partners, the solicitors for Buckham Brewery and the DPS who lodged this application.
Good morning, Sam Knight, current tenant and DPS of the Millet Road.
Rachel Trent McCarthy, current tenant of the Millet Road.
Thank you. We won't go round, because if we go to you, then we'll have to go to everybody else, as you're going to make representations anyway. Okay, so we'll start by asking the chair, that's me, sorry. We'll ask the licensing officer to present their report. Before I do, if everybody could just bear in mind, we have got a lot of submissions and a lot of people to go through. So brevity would be gratefully received. Please don't include planning considerations because they are not relevant. And you can expand on your representations, but please do not add any new information. Thank you. So we'll start with the licensing officer to present their report.
Chair, before we start that, might I remind you that we have two representees here. One, the responsible authority, the Avon and Somerset Police, and the other, Mr. Nigel Hellier. He is Objector 8 on your schedule of speakers. Their notice to speak came in late, so I don't know whether you want to consider that now and make a determination before we move to the licensing officer's report.
Thank you, Leslie. Yes, there were late requests from the police and from Nigel Hellier. As long as everybody is happy, I'm happy to let them have their speak. Anybody object to that? No, so we'll go ahead. Okay, Phil.
Thank you, Chair. Good morning, everybody. An application was submitted to vary the Millet Road premises licence PRL 0111 by Buckham Brewery Limited on the 23rd of June 2023. The application is to increase the licensable area, increase the hours for regulated entertainment and to amend the conditions of the licence. The application can be found at Appendix 1 and the plans can be found at Appendix 2. The details of the variation can be found below. The premises is a historic mill dating as far back as 1559. It has previously been in use for the production and processing of cloth and corn and was refurbished in 1996 into a public house. The mill is in the village of Road, which is 5 miles northeast of Frome, with a population of around 760 people. For the current licence, live music is indoors only, Thursday to Saturday, 2300 to 2330, and recorded music is indoors only, Friday to Saturday, 2300 to 2330. Sorry?
Regulated.
And that is the regulated, that is the regulated licence for activity. As part of the proposed variation, the regulated entertainment is to change to live and recording music indoors and outdoors on Sunday from 11 AM until 2300, Monday to Thursday 11 AM until midnight, and then Friday and Saturday 11 AM until 0100. Alcohol is also to be indoors and outdoors. Previously it was only indoors. Conditions. Part of the application seek to remove the following conditions from the licence. Annex 3. There should be no more than 75 regulated entertainment events per year, and these events are not to be held on consecutive days. Within this number are included no more than 3 outdoor events per year. Conditions on outdoor events. Outdoor events should be scheduled so that there is at least a period of 2 clear weekends between each event that is outdoors. No evening event occurring on either the day before or the day after the outdoor event. A plan indicating the positioning, output wattage and orientation of all amplified music speakers shall be submitted to the licensing authority for approval not less than 21 days prior to the event. And conditions on indoor events. All entrance/exit doors shall be kept closed during all music and entertainment events except for the purpose of allowing access or egress. All external windows shall be kept closed during music and entertainment events. The application then seeks to add the following conditions to the licence. There should be no more than 75 regulated events per year, within this number including no more than 10 outdoor events per year. All entrance and exit doors that face into the public highways, rather than into a car park or private area, shall be kept closed during all regulated entertainment events for the purpose of allowing access or egress. All external windows which face into the public highways but not into the car park shall be kept closed during regulated entertainment events inside the premises. The use of external licence area as edged red for supply of alcohol and use of the marquee and use of the external bar services will not be subject to conditions on outdoor events as detailed in this licence. The reason for the referral to the licensing subcommittee. A total of 57 representations were received that collectively relate to all 4 of the licensing objectives. A residents' meeting was held at the premises on the 14th of July. Attendees included a licensing officer, a representative of Butcombe Brewery, the current tenants, many residents, 2 parish clerks and a ward councillor. No compromise was forthcoming from the meeting, therefore representations were submitted. These have been considered relevant and the matter is for the licensing subcommittee to determine. We got some relevant observations as well. The 57 representations were made by 2 responsible authorities, Environmental Protection and the police, 1 ward councillor, the parish council, and 53 other persons. A summary of the representations can be found at Appendix 57. A map showing the premises location and the surrounding area can be seen at Appendix 58. A hearing took place on the 31st of August 2005 to consider an application for the variation of the premises licence as representations were received from Environmental Protection and several other persons. The licence was granted with conditions imposed by the licensing subcommittee. A copy of the decision notice can be found at Appendix 59. The conditions imposed are currently all still on the licence. These can be seen with Annex 3 of the current licence, which can be seen at Appendix 3. Legal implications. The Live Music Act and the Legislative Reform Entertainment Licensing Order 2014. Live and recorded music is deregulated between 0800 and 2300 hours on premises authorised to sell alcohol on the premises, subject to a maximum audience of 500 persons. The licensing authority has the power to remove the exemptions, but only if and when it carries out a formal review of the premises licence. Thank you, Chair.
Thank you, Phil. Before we move to questions to Phil, there's a couple of things I missed out earlier. Apologies for absence. Any?
Only from the representees. Would you like me to read those out or?
No, I think we already know which
Yeah.
ones. Okay, and any declarations of interest from anybody? No? Great. And one thing I should have said, I'll invite people to speak, but only speak when invited to do so by myself. Gives me a bit of power. Brilliant. So questions of Phil. So we'll start off. Does the applicant have any questions of Phil at the present time, of the licensing officer? No, any
No,
of the
thank you.
public or, sorry?
I was just saying no, thank you.
Okay, thank you. Anybody else? What about on the subcommittee? Marcus?
No, I think it's quite a comprehensive report, and I think at this moment in time, I haven't got any questions for you, Phil, but I reserve the right maybe later on if I do. Thank you.
You? Thank you very much. Okay, we'll move on now to the applicant to present their case, after which, again, questions can be asked of the applicant. Okay, would you like to proceed? Thank you.
Thank you. Yes, Chair. First, just as a preliminary, could I just take my jacket off? I see it is one of the hottest days of the year. Thank you. So the way I propose to proceed forward is that I will outline the application, referring to some of the documentation that is in the bundle, and particularly the supplemental bundle, which I think clarifies aspects of the application. And then when I finish, if you have questions, and I'm sure there will be questions, then I may be able to assist with certain aspects. And Dominic, who is from Butcombe Brewery on my left, can also assist in that regard. And just by way of introduction, Butcombe Brewery have owned the premises since about 2011, so around about 10 or 11 years. It currently operates as a tenanted premises. Dominic is the area manager responsible. Butcombe Brewery, a company that has operated for many years and generally southwest based, has about 60, 70 premises in total, of which 18 are tenanted. And that's important in this respect because the tenant operates with the benefits of quiet enjoyment under their tenancy agreement, and that's perhaps relevant to the history, and I'll come on to that. And they run their own autonomous business under the supervision and with the support of Butcombe Brewery. So I think I'm sure you're aware of the difference between managed houses and tenanted, but I think for the people here that may not be, it's worth just mentioning that at this stage. To my right are effectively the tenant couple, and Sam, who would be the one I think would speak, is DPS at site. And to introduce him, he has many years' experience in the hospitality industry and has worked at large venues, operating large events, being involved in Bath and Bristol and around those areas, and Bath Racecourse in particular, and was involved and headed up the licensing aspects of that organisation, and was involved in SAG, the Safety Activity Group, which again I think is relevant when we come on to the specifics of this application. So it is certainly worth introducing, but I will proceed and just present the application as I go, but they are extremely important in that regard. So history to the premises. I believe the premises were licensed in about 1996. Obviously, they came under the current jurisdiction in 2005. The Licensing Act 2003 came into play, and there was a conversion and a variation. And since that time, I'm not aware there's been any significant licensing applications. And my clients took over the premises as premises license holder and operated it and have had tenants in there. So far as one particular part of the history is concerned, it was necessary during and after COVID for the company to take action to remove their tenant who resisted that, and there's reference to it in the representations. But the only point I would say there is they vigorously pursued and opposed proceedings to ensure they got possession, which does take some time. And that was achieved from October 2021 onwards through to finally in April 2022, and Dominic was involved in the last part of that in securing the occupation. So the reason I mentioned quiet enjoyment at the beginning was because a tenant, quite rightly, you have to go through legal processes and it can take some time, but Buckham did that to remove that tenant who had been there a couple of years. Current tenant was sourced, found to be extremely suitable, and brought in play in 2022 and has been there operating and improving. When they first moved in, they had some work to do, it's fair to say, with decorations, improvements, repairs, changing some of the layout a little bit, and part of the application deals with that, and I'll come on to that into more detail. But this is a small business for these two individuals, and the purpose of this application is not to cause public nuisance, it's not to cause crime, disorder, or undermine any of the objectives. It is to seek to make this a viable business going forward in a number of different respects. And that's the overall tenure. And we believe the application as before you now, with the measures that are proposed, is a good way forward. And I will go to the detail on that just a little bit. But that's the background. I'll now turn to the supplemental bundle, if I may, because I think that's quite useful and it will dot about a bit. So if you could have that to hand. Page 11 has my clarification document, and I'll come back to that because that's where we are on the application. But if I can take you to page 19 onwards, I think those are quite useful documents. And pages 19 to 24, 25, what they do is hopefully give an indication to you, if you don't know the premises, as to how this site is being positioned and the various aspects. And that highlights the nature of the food that is being provided and offered, new menus and an indicative drinks menu. That this is not, and if you've visited the site, and I believe two members this morning have visited the site, this is not a city centre cheap alcohol venue. This is a venue that needs to attract and develop certain multifaceted aspects to the business, and one of those being important is the food provision. And you can see the menus. I'm not going to go through the menus. I'm sure you've had an opportunity to have a look at those. You can see the price point there, and the drinks menu, which I think is important because it does show the price point for the kind of alcoholic drinks that are available on that menu, and this responsible operator seeking to develop the food. The food's important. You've seen the structure of the building. There's parts set out to a restaurant, parts to a bar, parts to a function room, and those are all important parts. And then there is the external layer, and that's what they're seeking to develop within boundaries. So I think those pages are extremely important. If I could carry you on, and I will just refer to them for everybody here, but you will see pages 26 through to 31 are a document prepared by Mr. Knight, Sam, which I think is helpful and covers off some of the points in the representations that have been covered. I'm not going to go through those. If you have questions on particular points, I'm sure we can assist you on those. I think it's important in relation to the images. You can see the images of the building. You can see in particular on page 29, 30 has the kitchen garden and what is being developed there, which is out towards one part of the building and nearby to where a children's play area was, which hasn't been there in the tenure of Sam. So that has gone and has been gone for some considerable time. So you get a flavour of the pictures and the layout externally in those documents. Pages 32 to 34 are an example of a management plan which was put in place for an event around the current celebration of the coronation. And again, I'm not going to go through that, but that comes included that. That's not part of, we've just done this because we've made the variation. That was for an event that was held, as you can see, in May, with no enforced obligation, if I put it like that. So that was done because it is the responsible thing to do, and my client wanted to do that. And that was tailored to that particular type of event. And I'll come back to those as well as I go through the proposal. But in the conditions, in discussions with the environmental health officer, who I know is here, there was suggestion and talk of a noise management plan. So we sent that as an indication as to what is already done to work forward on the kind of events. So that hopefully gives you an indication of the type of work that is already done and in operation. So turning to the application itself, we lodged the application in June, and we were going for flexibility, and we received numerous representations. Since that point, we've looked at the representations. We don't feel we will cause a nuisance, but we've sought to restrict down what we're looking to do, and that is part of what is formed in the clarification document, which is at page 11, I think, of the supplemental bundle. And I will just go through that and each of the different parts of the application. And I think it might be handy, I'll refer you to a couple of pictures for each part of that proposal. So the variation, you'll see that I now talk about 3 parts: variation of the layout, alterations to activities, and then events or outdoor regulated entertainment. So just taking those each quite briefly. Variation to the layout, the internal layout plans, I think were outdated. So I included those to update you on the plans, which I think are now more or less, maybe not 100% correct, but there's nothing significant occurring there. On the external layout, we sought to bring in the boundaries of the premises for supply of alcohol, and that primarily has the purpose of enabling sale of alcohol by external bar serveries on occasions, to give supervision of the external areas by persons out there, but also to assist in service. Again, if you've been to the premises, there is a pizza oven area for food, which doesn't need to be licensed and has been operated within the boundaries and parameters of the law. But we would seek that as one of the points for service of alcohol. And then the other one is near to the main building. And if you look, I think on page 15, you'll get the picture of what's called Summer's Day, which I think is a good example of what we're talking about here. Those 2 orange shadings show the positioning of the external bars, shrouded from the vast majority of the residents by the building itself. And it's not extending, because at the moment there can be consumption of alcohol out there until the terminal hour. Now, obviously, with the notable exception perhaps of days like today, the vast majority of time the weather is not going to permit being out there considerably late in any event. So that's sort for that flexibility. And you can see marked on there, and it's on all of the plans, allotment area. If you saw that area when you visited, it is part of the kitchen garden. It's where I think the children's play area was, but certainly isn't now and hasn't been for some significant time. But that's just marked as an allotment area. It's not an operating area, and it wouldn't be suitable for that. So that's the external part of the layout, and the layout we're seeking for that flexibility. Alterations to licensable activities. Internally, we're seeking to bring live music and recorded music in line with the sale of alcohol. So a number of the representations talk about extending the hours the premises are going to operate. That's not correct. As you will know, we are authorised under the existing premises licence for certain hours for sale of alcohol and then for opening. We're looking to bring internal regulated entertainment into line with those. So there is an extension of hours on those, but we're not seeking to increase the overall number of regulated entertainment events in a year. It stood at 75, it stands at 75. We're not seeking to increase that. it is to give a little bit flexibility and develop that aspect to help this business thrive and survive. It is, and I will say this, and I may come back to this, difficult times, as you will all be aware, for licensed premises, and they have to, within the law and upholding the licensing objectives, ensure that their business is effective and can work. And this is what's driving this within the boundaries of the licensing objectives. So hopefully that explains a bit about the internal bits. Externally, we're seeking regulated entertainment, and we were talking about number of different events, but the clarification document, I think, sets it out hopefully quite well, that we're seeking a total of 10 regulated entertainment events, where at present there are 3. There are conditions on the license headed conditions applying outdoor events. And in my initial application, I sought for marquees to be outside of those 10 events. So I sought that marquees didn't or weren't having those conditions apply. I still seek that, and there's nothing, that doesn't mean that you can't do that. One of the conditions says outdoor events 23:30. I am saying that I want the marquee excluded from that terminal hour, and it's explicit in there. You can grant that. So you would leave it at 23:30 for anything not being a marquee, if you grant my application. And then I am now saying midnight for terminal hour for regulated entertainment in the marquee and sale of alcohol in the marquee with a 00:30 finish. So still not extending hours of the overall operation, and we've restricted it down. And the types of events there are put into 3 family day events, Summer's Days, if you like, something around the Summer's Days family events, one day, and we are seeking to remove the restriction on consecutive days or consecutive weekends, not least because the premises might do an event, family event, beer festival on a Saturday, Sunday, or want to do. At present, can't do that, but that's what they're seeking to do. So, but it would still count effectively as part of the 10 events. So we're not going beyond that. So the summer events there, and we're saying live music, 10 o'clock. So we're actually pulling back from the current 23:30. Recorded music, live music, 2200 hours, and effectively finishing at 2200 hours. So alcohol would finish by 10 o'clock outside as well for those events. Beer festival, effectively very similar, but similar type of operation, and the same kind of terminal hours of 2200 hours. So again, pulling back at present as one of the 3 you could have till 23:30. So we're saying those, we're looking at bringing back. The third type is wedding or similar function, and we're saying maximum of 160 people. So it's a smaller event, but what we seek is terminal hour for recorded music and live music midnight and alcohol midnight, and then the event finishes by midnight 30. And when you mix those 3 together, family days as they're headed, food or beer festival, weddings or similar functions, it would be a total of 10, but just with the distinction on the hours. Just touching on the confusion around when I first lodged the application and excluding conditions external areas, is the marquee external, is it internal? Should I have removed all the conditions and started again with the premises license? I have to say I thought about it, but it is easy with hindsight to go, perhaps we should have done it a slightly different way. But then I didn't want to look to remove everything and be seen to be trying to get rid of everything. So that's why. But this document, I think, shows what we're seeking now across those 10 events effectively. And just to go through them, if I can direct you to the pictures that follow, which are, I think, 15, which I've already taken you through the Summer's Day indicative, and 16, and then 17. And much of the detail is fairly obviously there. So you have the position of the entertainment, and you can see they put donkey ride, the village day style thing. So it's stalls and that kind of thing, and you can see where they're placed. The orange, I think, is the entertainment point, and you can see that is out near to where the allotment. So facing away across open fields where there are no residents facing in that direction. So designed away from that, and the other way to an extent, the building blocks, the sound travel to an extent, and then the same kind of layout for the marquee in the same position, which is page 17, as you can see. And on that, this document was prepared by Sam. You can see, particularly on the marquee one, sound bafflers on the certain sides of the marquee to assist in preventing noise travel in certain directions, location of speakers facing away, and the occupancy there. And I'll come back to this. And there would be a noise management plan put in place in discussion and consultation with the environmental health officer. So this is the proposal that is put for you in the different aspects. If I can come on to the representations, and obviously the parties will speak for themselves, but just in summary, on the police, hopefully in the documentation you'll see the points that are covered off. This site, certainly under this tenure, has had no issues of crime and disorder, and I don't think any are referred to in the representation, but I'll let the police put their point forward. We have had some discussions. There was a discussion yesterday, and this has led to some suggested conditions from the police, which I've had an opportunity to look at very briefly this morning, but it perhaps might be something we come back to if the police go through it line by line, and I can then have a look. I've now just got a copy on my phone, but it may be easier for you to have photocopies when the police are speaking, so that can talk to that. But I think, subject to some comments, they cover off concerns. They want, I think, some tidying up, which is, and I'm paraphrasing, challenge 25, don't have a problem with that. They want a drugs prevention policy. Can we be very clear, there is no drugs issues at this site or any evidence of it under this tenure, but happy to agree a condition around that. There is a CCTV condition. I think the only point around it is to clarify what it needs at site, because it does have some CCTV, and the nature of the venue, which, as I've said, significant restaurant offer, is one which it does not need an all singing, all dancing 30 camera system, and I think the police would accept that, but have to have a condition on requiring CCTV, but just around the actualities of it. There are then some conditions around event management, noise management plans, and risk assessing, door supervisor, that kind of thing. All of which are, in principle, quite happy to agree to, but I don't think I'm in a position to go through them line by line because I haven't got them in front of me just at this moment. So I won't say anything more than that on the police. I think the police have acknowledged good operator, and the premises don't cause any issues, but I'll wait and see where the police are at on that, and I may have questions for them, I think, so on that. Environmental health officer, we've had an opportunity to have a discussion, and I think we're more or less there on that one, but I'll come back to that because I want to go through the conditions, which I know you're keen for me to clarify on, and I'll go through that. But safe to say we've had some good discussions, and I think the amended format of the application in its terms is acceptable to the environmental health officer. But again, I may have some questions depending on what where he comes from on that. On the residents, you have a large number of residential objections. You've been to the site. You know the physicality, or certain members of the committee have the physicality of the site. And when you put together the measures we are proposing, the numbers that we are now restricting to, the hours that we are talking about and the type of events, so pulling back for some of them from what we're authorised now at 23:30 externally, linked in with a modest extension on effectively 6 or 7 occasions a year, from 23:30 to midnight, we say that that is a reasonable application for consideration, particularly with the additional conditions, and that the physicality and the nature, a lot of the representations are some considerable distance away. There are some that are nearer, but we don't believe we will cause a nuisance. And other than that, I may have some questions, or I may come back to the representations on those points, depending on what they say. I'll now just turn again to the clarification document, and you will see the conditions that are offered on page 14 of the clarification document. The first one, all windows and doors must be kept shut whilst regulated entertainment is held internally. Happy to do that. There is a sort of a similar condition on. We were seeking some flexibility on that when we lodged the application. And again, that was aimed at, if you've been in the building, this, I was in it this morning, and in parts even at earlier, and it was on a very warm day, it gets warm quite quickly. It's an old building. It has physical attributes that protect noise escape. But all we're seeking was some flexibility for those that were facing away from the residents, possibly in towards the car park, to maybe leave those open on occasions. However, discussed with the environmental officer, happy to keep it effectively as it is. So that's condition 1. Condition 2, noise management plan should be submitted to the licensing authority, and actually that may be with the environmental officer to the environmental health officer rather than the licensing authority, but matter for you. Shall outline measures to be taken to minimise noise disturbance from regulated entertainment when events are to be held externally. We've seen one that we've included in the bundle, and it's indicative, but it would be different for the other events. So there would be one for marquee type events, one for the beer festival, family days, and summer days, etc. So person responsible for the overall control of noise shall be appointed, and this nominated person shall make regular patrols of the outdoor of the premises during any external regulated entertainment to ensure those noise levels don't cause a public nuisance at nearby residential premises. Well, if you look again in the noise management plan that's in the bundle, that's Sam, and he'd included that in any event. So his experience was already telling him what to do, but we're happy to agree a condition on that. And then all nearby residential properties shall be notified by letter or social media at least 7 days in advance of any external regulated entertainment event. Should be provided with a contact number for the person responsible for the overall control of the noise of the premises. Spoken to the environmental officer, he would like slight tweak on that because he would like written notification effectively by letter to a certain radius, which is agreed with them in the noise management plan. So I think the concern was if we were notifying the whole village, I don't know how many people live in the village, but they live a significant distance away, it would be many, many hundreds into thousands of letters, whereas with nearby, we're happy to do that. So that condition there. So those are conditions effectively discussed around the potential of noise issues and agree with the environmental health officer, subject to what he says. I now then come on to, lastly, the document that your licensing officer kindly supplied this morning to try and clarify, and I do understand the issues, but I think what I might do is I think it does clarify the position with what I have said to you in relation to the conditions that are there. But if I spend a few minutes between now and when I next speak, possibly if I have any clarification on that, then I will clarify on that. But I'm hoping that kind of takes us to a position as to where we are. And just one last point. It's not technically relevant to licensing, but it appears a number of times, and that's this Section 106 agreement on the island. We're bound by the Section 106 agreement. We will comply with the Section 106 agreement. I can't say more than that, and I don't think it needs to trouble you more than that, but I will say that. So I will pause there. I thank you for your forbearance, but it is important to try and put it into context and explain the documents for everybody who is here and remotely. So questions, I will try and deal with any I can, or my clients who are both here. Thank you.
Thank you very much. Does anybody else on behalf of the applicants wish to speak, or should we go to questions?
I think, as you mentioned earlier, Chair, in the looking to try and keep this brief for everyone, I think we'll leave it there.
Thank you very much. I've just got to read out, it seems that earlier on, we said that only one division councillor was in attendance at the residents' meeting. Actually, both division councillors were in attendance. So if that could just be noted. Thank you. We'll move on to questions. We'll start with the subcommittee. Marcus.
Thank you, Chair, and thank you. Very comprehensive summary. I've got several questions. I don't know whether to. I don't want to sort of throw them all at you at once because it sounds so. I might go on a sort of question by question basis if you can bear with me on that one, Chair. You were talking about the previous tenant, and I might roll a couple of questions into one here. You talk about the previous tenant, and obviously him then vigorously, trying to stay in the premises, which obviously is probably quite unusual for a tenant to try and stay in the premises nowadays. But when you say they vigorously defended it, but when did you start that action against them, bearing in mind the history of the property?
I'll ask Dominic, who knows more of the detail than I do on the timings, and only to say I think it was, if I say, as many things were complicated by COVID and removing people from premises because he was, I believe, living there. That was one of the things, but I'll hand over to Dominic. I think it was 2021. It took some months to go through court proceedings, but Dominic has more knowledge than I do.
It certainly started well before I joined, which was March 2022. I believe my microphone is on. Yeah, is that better? So it certainly started well before I joined. As I understand, it was at least 12 months of eviction court proceedings, solicitors' letters, significant amount of our time and effort in removing Mr. Burgle. He unfortunately tried to put his business into the name of someone else, who then turned up at court. I think there were a number of court hearings in Bristol, and the eviction order was finally granted in October 2022, but I think not until April 2022 was it then enforced, when we were then allowed to visit Mr. Burgle and ask him to leave.
Thank you. I'm working, this one might be again another one for you actually. I'm working on through what you were saying with regard to how the site is being positioned, and we see the menus and we see what operationally you're trying to do, but I think you also point out later on that times are difficult. Events like, I don't know, Rugby World Cup, for instance, other things might pop up, and tenants, and appreciate you might not do this, but tenants, suddenly, finances aren't what they are, and actually maybe if they dumb down a bit, as the premises license holder, what control do you have if suddenly there's a Rugby World Cup final and suddenly they're selling jugs of beer for £10, etc. I mean, what control as premises license holder do you have over that tenant?
I think I'd say two things, and then I'll go to Dominic again. The two things I would say on that is we present what we do before you. You can only judge what is before you. And Sam is here to explain his vision for the business, which is what I've tried to verbalise, but can't do justice to because I'm not there all day. The type of premises it is, I would say, does not lend itself, even if they tried to do that. The nature of it is not a premises that would be attractive physically to that kind of operation. But I'm sure Dominic will come in and say we would take action as we are allowed to under the law. But so I'll hand to Dominic on that.
Yeah, I think I'd agree with Tim. It's not what we see for the outlet. We certainly want to make sure that where we have an opportunity to position and use price and product as a way of making sure that keeps the outlet away from maybe that kind of influence. There will always be events that come around. Like I said, if we think back to last year, a royal funeral and a coronation that we'd never had before. But again, I think you'll see from the type of plan that was put in place for the coronation event that I wouldn't be expecting to have an issue. And if there is an issue, then I believe both police, in terms of the Licensing Act and the licensing officers here and ourselves, there's enough in the licensing guidelines that there are in order to make sure that effective action could be taken.
Just to follow on from that, and I'll ask, I think it would be good to hear from Sam, because it's what you're faced with, who's going to do this. The company is the brewery and the operator there, and what he wants to do with the business. And I would just preface from conversations that we had this morning, this kind of site requires a lot of work and you've seen how it is and the food set up as a restaurant and how that needs to be operated. And they, I don't think I'm betraying confidence, is hoping to go for some rosettes at some point. That's one very important part of it. But it needs this support to be successful as is proposed, which will be, I think it is a very good operation now to take it on its further evolution, but maybe Sam can add to that.
So yeah, the only TV that we've got in the premises currently is in the downstairs wheel room, which is where we've got a snooker table. It's kind of like a games room kind of situated. We've shown the men's football from last year, tail end of, and the female World Cup was on TV for the ones that we could open for 11 o'clock. But again, it was a very small number, between 5 and 10 people. Sometimes I was down there watching it by myself, but it was very heavily come down, have a drink, bar board, which is a sharing board of chicken wings, chips, etc. So you try and tie in the food element with it. We're not a sports venue. We don't wish to be. We don't wish Sky Sports or anything else because that's not where we want to be. The food is our business plan situates that because of our buying prices, etc. needs to be 65% food led, not 35% on the drink. So the push is really on driving people towards the food as opposed to the liquor.
And just again, perhaps one point of clarification, when Sam talks about a snooker table, he does mean a snooker table. He's not talking pool, he's talking full-size snooker table, which is a rare thing, I think, these days.
Thank you. I think you probably see where I'm coming from with this. Obviously, we've got your license, you've got the license, and we don't want to be in a position where suddenly a change of tenant or I don't know, tenants have a total change of personality and suddenly we're in a position of reviewing a license. So that's something we need to take into account. I have so many questions here.
Sorry, could I just add something on that point? To agree with you entirely, that's why we're looking to make sure that this is part of the license, so that if we do have a change of tenant, we've already got a license in place that would suggest how we want them to operate the business.
I don't know whether to let somebody else have a go. Just one final question, I think, although there was an awful lot, especially on the live music. But I think I've got notes on the live music. I can go through that and figure out. But by extending, I mean, that's just for clarification, by extending the licensed area to outside, we talk about regulated entertainment. Well, actually, that would then, just for clarification, allow you to have regulated entertainment in that licensed area up to 75 times a year.
No, because the condition would be 10 outside. So the condition, if it doesn't work, I'll amend that condition, but the intention of the condition, and I'm looking to my left of the licensing officers to an extent, the request is a total of 75 internal and external, with a limit on external of 10 regulated entertainment events.
So for clarification, that limit of external events includes regulated entertainment outside.
Regulated entertainment, yes.
If the licensing officers want to make a comment on that.
We've got a series of questions and we'll come to that later on at Albert.
Okay, thank you. Hugh, have you got any questions?
Thank you, Chair. To you, solicitor or lawyer, I don't know what your title is. I was quite amazed when you made a statement that you've not got a drug problem. You're not working on that establishment. You're not walking around the perimeters of the site to know what's happening out there. And I think you should come up to the 21st century. We've got to move on. Wherever we go, we look at drug policies. Very, very important. And the other business, CCTV, that is a plus for your staff as well as the public at large. And the more you can apply that, the better it is for your business. So when you're representing an organisation, please don't talk in a third person because that's not fair. You don't know what's going on there. And the other item is the door supervisor. If you're going to have such a large amount of cars come there, we could have supervised the parking.
Can I, if I take each part individually, you're absolutely right. I don't work there. The point I was trying to make was, having discussed the matter with my clients, I am effectively presenting this case on behalf of my clients. I was saying, and I perhaps should have said in their opinion, there is no significant drug issues outside. I wouldn't ever say there's no drug issues. I think you quite rightly say it is a societal problem, and probably in the vast majority of premises you would find some detail. But I'm saying, to clarify that, my client would say there is not a significant drug issue, but they're happy to have a drugs policy, and Sam will clarify on that point. And on CCTV, happy to have CCTV in a CCTV condition. It is just around the right balance, because whilst you're quite correct, equally there is an element of the type of premises and I suppose intrusivity of having too much CCTV. You necessarily have the same CCTV in certain types of premises against a nightclub. That's the point I was effectively making, but there is CCTV, so we don't oppose CCTV at all. On the supervision of the car park, I'll let Sam perhaps deal with that and how that's done.
So yeah, in terms of when we put together the event management plan for Coronation Day, that wouldn't have been an SIA steward. That was part of the car parking group that we use or used to use at the racecourse. CB Protection, they supply car parking stewards and licensed SIA officers as well. So yeah, it was just 2 people because the car park isn't lined. So when people do naturally park, they do leave bigger gaps, where if it's an event where you're going to know you've got traffic, it's better to have people to park people straight to maximise the car parking uses there.
We're talking about the car parking. How on earth are you going to cater for all these vehicles that are going to come there?
We've held 30 events already this year, and we haven't had an issue with traffic management or anything on that front. Weddings, most of the ones we've had, there's been a couple that have had double-decker buses where they brought people in and taken them away. So there's other solutions as actually to parking on site. Some people do like to use vintage vehicles as a mode of transport. A lot of people stay locally at Holiday Inns, so they kind of come across, they car share and whatever, and get taxis back later, leave their vehicles overnight.
I'd like to I'd like to ask my question again, actually, because I got my unregulated, it must be a bit warm in here, I got my unregulated and regulated entertainments mixed up. Well, my question, I'll just check with the chair what I did say. When I said that would allow you to, I meant unregulated entertainment, and that's the clarification I wanted. Excuse me, I apologise to my licensing officers who must have thought I was having a slight turn.
Unregulated, deregulated, that exists in any event, as is now. That won't change.
Can I just ask, you asked for a deferment of 2 weeks of this hearing. Any further consultation go on in that 2-week period?
Yes, what we did was had the opportunity of speaking to the police and the environmental health officer, and that was the basis of the clarification document, which I believe was circulated to those parties that have made representations, was intended to do that. As you know, we had a public meeting during the representations period. So the consultation was, or clarification, if you like, consultation, mediation, was to produce a document which reduced the scope of the application, which is the clarification document, which was sent, I believe, to everybody.
Thank you. Any more questions from the panel? No? Leslie?
Chair, no questions from me.
Thank you. From the licensing officers?
Yeah, we've got a couple of questions, that's okay. Referring to the clarification document, Appendix 64, just to clarify, you refer to weddings and similar events. Can we just clarify what a similar event is, or what a similar event would be to a wedding? Yeah, can you answer that one first? Thank you.
Yeah, I think I'll probably ask Sam to do that. I think it's wedding functions within the marquee, subject to the same restrictions on 160 people and that kind of thing, with an element of entertainment, but Sam may be able to clarify and include it, just give a bit of flexibility.
So yeah, similar type events, still based in the same format of a 3-course sit-down dinner and music afterwards, but it could be something as a charity ball or a fundraiser ball.
Yeah, so it'd be more of a function as opposed to a wedding or similar event then. Thank you. And that would be subject to the proposed terminal hour of the midnight and the event to finish. So license activities to finish by midnight and then the event to terminate at 0:30 hours. Yeah, thank you.
Correct, just for everybody.
Going on to some of the conditions. So in relation to the regulated entertainment, condition 75 regulated entertainment events, within the original application, the word entertainment was removed or missed out. So it says 75 regulated events. Can you just confirm if you are happy for the word entertainment to be included? I think we had a conversation about that, didn't we?
Yes, I think when I reproduced the existing, I just missed off the word entertainment. I looked back to see if there was a good reason. I couldn't find one. We had the exchange about it. I'm happy to confirm it's keeping in entertainment.
Okay, so then the condition would include the word entertainment. Thank you. And then another part on that would be so when you refer to a year, is that a calendar year? That is what we typically go by in licensing. Is that something you would be happy with as a suggestion per calendar year? Yeah.
Yes, happy a calendar year.
Okay, thank you. Going on to the condition in relation to doors and windows being open, and so part of the original application was to seek to have them open onto private areas, not where residents are. The clarification document then came with a different one. All windows and doors must be kept shut while regulated entertainment is held internally. I would suggest as well including except for the purpose of access or egress. You happy with that?
Yes, happy with that.
Thank you. So that'll be both of the window conditions, yeah. And then I'll just pass to Jack. I believe he's got a couple of questions as well. Thank you.
Yeah, first of all, thank you very much. Going through there, on your original license, there is a condition on there, the music from outdoor events will cease at 23:30. You did touch on that with your presentation. And from your presentation, is that now to be, are you looking for that now to be that music from outdoor events shall cease at 2200? Or keeping that the same?
No, I think if you look in the clarification document, hopefully what I'm saying is effectively 10 events up from the 3. If it's a family day, we're saying 2200. A beer festival, 2200. If it's the marquee midnight, if it's outside of those, 2330. So it's moved on from where we lodged in the original application. So
it's kind of an issue, really.
It does. I think the paramount is if we're doing something in the, I'll check with my client, but I think if we're doing something in the marquee, we would like the midnight. And the outside of those probably would be 2200 would be okay.
I'll come on to the marquee secondly, but this is to do with this particular condition, which is currently on the license.
Can you just bring your mic closer, Jack?
Sorry. This is to do with this particular condition, which is on the license and hasn't been asked to be removed, which states music from outdoor events shall cease before 23:30. Within your clarification document, you then mention family events and beer festivals terminating at 22. So I'm trying to get clarification between the two.
Talking to my clients, the simplest way would be to say, anything in the marquee, 10 events, anything in the marquee midnight, anything outside the marquee.
I'll speak about the marquee in a minute.
Yeah.
So
anything outside the marquee, 2200.
So that condition.
It can be subject to where we get to with the marquee, because I need to hear your questions. But yeah,
I'm just looking for clarification in relation to that. That if we did progress on, then that condition would change from 23:30 to 22.
If my submission's accepted, yes.
Okay. Thank you. The next condition I just need clarification on is the condition that you've was on the application for the variation, which states the use of external licensed area as edged in red for the supply of alcohol and use of the marquee and use of external bar services will not be subject to conditions on outdoor events as detailed in this license. What that suggests to me, that particular condition, is that with the new area which is being promoted as part of the site plan, then as you've applied for regulated entertainment to go to the same terminal hour as alcohol, then regulated entertainment could be up to that terminal hour of midnight or 1 o'clock outside.
Yeah, the wording, I can see how the confusion has arisen. The intention of the condition essentially is saying the use of the external area for the supply of alcohol and use of marquee and use of external bar serveries, which we mark on the plan, wouldn't be subject to, but outdoor events would be subject to. So the three.
May I make a quick suggestion? And you may, Chair may give you time to have a conversation with your client. That with regards to music and outdoor events which cease before 23:30, that then shall cease at 2200, and then provision of regulated entertainment within a marquee by way of live music or recorded music to terminate on these occasions at midnight and event to finish at 0:30. Because that's what's in your document, but it just makes it clearer for everyone to understand.
Yeah, I think that's right, and that's where we were trying to get to in the clarification document. I understand the confusion where it was different.
But I think that might make it clearer for the residents to understand.
Okay.
The 10 events include weddings or functions, as well as a beer festival, as well as a fun day. And the marquee that you're proposing to be used to midnight and finish at midnight 30.
Happy to agree that suggestion.
Thank you very much, Chair.
You don't need time to discuss that between you. You're happy with that?
Yeah, I think we're fine with that. I may come back to it if I need to, but I don't anticipate I will.
Thank you.
Chair, I wonder whether Jack could repeat the proposal so that everybody in the room is absolutely clear as to what has been proposed and what Mr. Shield, on behalf of the applicant,
No, that's fine.
could be agreeing, subject to final confirmation.
The wording that I've used is taken from the clarification document. Sorry, it's taken from the clarification document at paragraph 3, outdoor regulated entertainment, subparagraph C, where weddings and similar functions. And the wording that I've said there is taken from the third line down, provision of regulated entertainment by way of live music or recorded music to terminate on these occasions at midnight and to finish at midnight 30. So it is wording from the clarification document, which is within the bundle.
Is that okay, Leslie?
Yes, that's fine.
We'll continue around the table. Just one moment. We'll just do the other ones first, and then we'll come to you. Any questions from the police at the moment of the applicant?
Good morning. Can I just have some clarification? You obviously opened up your presentation around a tenanted pub, and you've obviously given a little bit of a free rein to do what they want. You've got the DPS, and then you've got the premise license holder. And obviously, I want to try and establish what the overall management is from the premise license holder, because obviously previously the premise has been a little bit of a problem, and it's certainly not been our experience that there's been that support from the brewery.
Can I just clarify? I didn't say freedom to operate. They have right to operate and the right to quiet enjoyment of their business. So they are bound by the terms of a commercial lease. And if they breach that lease, then they can be removed. It is a very common situation across the hospitality industry, but many, many different industries, and must comply with the terms of that lease. Within that, he's designated premises supervisor, so he has to comply with the terms of the license, hold the licensing objectives, and can, with assistance, autonomously run his business and, for instance, seek to get rosettes for food, provide entertainment within restrictions that are imposed or agreed. The supervisory role is to assist in promoting the licensing objectives, and is here to assist in this application, to assist in the business running well, because everybody wants the business to run well. So there are mutual obligations. As regards to the history of the premises, this, as I understand, it was one tenant, and the brewery took action and removed them. So I would say they did take action. Does that help you? I don't know, Dominic or Sam, want to add anything to that?
I certainly can't speak to previous actions, because obviously I wasn't with Buckham. But as far as I'm aware, since I've been here with Buckham and our current tenant, there haven't been any issues that have required any concern from us. We would regularly meet with the tenant. We'd regularly meet and discuss things with either police, environmental health officer, licensing officers, as I do with a number of councils across southwest England. And if there were any concerns raised, we would discuss those and act accordingly.
Thank you. It's just that I obviously just wanted to clarify, because as I say, obviously it wasn't our experience of 10 months of trying to obviously deal with the existing DPS and deal with the brewery with no support. I just wanted to know what difference there was going to be now with your new tenant to the previous tenant that you had there, because what we wouldn't want to happen is, I'm not saying that obviously problems are going to happen, but if we find ourselves in that position, is it going to be another year's worth of issues at the premises before actually any action is taken by the brewery themselves, rather than the police taking that action?
Yeah, as I said, I can't speak to what action was or wasn't taken because I wasn't there, and it would be unfair of me to say what colleagues may or may not have done. All I can give you is what's happened in my tenure here, which is there have been no requirements. There have been requirements with other tenants and other councils, but obviously I can't bring those into the hearing today. But other than to say we would take, as we did, I believe then, robust action. You know, eviction is not something that you undertake lightly. It's unfortunately something that, as Tim said, is covered by a commercial lease. Therefore, you do have to go to court. You do have to go to the High Court. You are back in the Court of Appeal. And if the tenant doesn't want to go, they can make it very difficult for them to leave. And 10 months during COVID with court backlogs, I think from what I saw in a number of other instances, was just that's how long it was taking at that time. And we didn't supply Mr. Burgle for any of that time. So he was then breaching his agreement by purchasing alcohol from somewhere else. So we didn't continue to send him beer in order for him to do that. He was purchasing that from somewhere else.
Chair, this doesn't strictly go to the 4 licensing objectives, so you may want to curtail any further discussion about it. Thank you.
Okay, thank you. I'd only add that perhaps you want to review your internal procedures, as it would appear oh dear, inference was that you were slow to act and support the police, perhaps, and it'd be nice to think that you'd updated your internal procedures to make sure that didn't happen again. That's all I'll say on that.
Yeah, I would say that since I've been here, I would absolutely say, as I said, I've dealt with licensing officers and EHO and police with regard to, you know, another tenant in another part of the world, and that I would take robust action.
Thank you. Sorry, we're going off point here a bit, as Leslie is indicating to me. So I'll bring us back on. Right, we're going to, I think there's a gentleman over there wanted to speak. Do you want to go up to a microphone there, sir?
Chair, EP first, please. EP.
Oh, EP, forgotten you.
That's okay, thank you, Chair. I've got no questions, thank you.
Chair, before I address the point that I wish to intervene on. Could I ask for 2 points of clarification from you procedurally? One is, sorry. If I'm not getting my steps in today, I'm getting my squats in, Chair. Point of clarification is, do we as residents have the opportunity to ask questions? Because we weren't given the opportunity to ask questions of the licensing officer, and I for one had one. But that might get swept away with the point of order that I wanted to raise, which is this. As you may be aware, I speak on behalf of both Road Parish Council and Telesford Parish Meeting. And I've been nominated to do so on their behalf. I'm also a parish councillor on the Road Parish Council. And we have sought numerous times to clarify exactly what form this application now is in. I strongly suspect you as a panel have the same difficulty in trying to understand it. The way that it was summarised by the licensing officer quite reasonably and correctly was summarised in its initial form. And then as we've gone through, it appears that the clarification document is taking on a status of actually amending that application. And in fact, we've now had a further amendment made because a point that was raised in the public meeting back in July, memory serves, as to the definition of outside, the fourth bullet under section C of the original application, was raised in that meeting, and it wasn't clarified then. It hasn't been clarified since, and it hasn't been clarified in the clarification document. Only now, when the licensing officer puts it in this hearing, we then hear that it will be amended in the way that's been worded. The net result of all of this is that we have consulted on, and we've attended here today, to address an application which is fundamentally different to what it was presented when it was first submitted, and is now again fundamentally different from that which is amended to by way of a clarification document, if the council consider that the clarification document does enjoy the status of amending the application. The bottom line of this is that we are, I speak for myself and others that I have spoken to, not everybody, we're confused as to what the application is, and I strongly suspect so are you. And it isn't the right way to go about matters of this nature. And so my point of order, in order to try and rescue that, so that the right procedure is done and that you are able to operate within your powers, is that we have a short adjournment and the applicant clarifies once and for all what their application is. That way we can ask questions about that application and we can give our representations on that application, because I strongly suspect most of the people here assembled today, and I am, for one, I'm here to talk about the original application, because that is the application that is before you and that was summarised by the licensing officer. It seems to me that if the clarification document is taking on a status of amendment, that it should be made explicitly clear that that is the case, and that were you to grant the application as it stands, that is what it would be, including the wording that your legal advisor just clarified at the point at which I asked to raise a point of order. So that's my suggestion on how to deal with that, Chair. It's of course a matter for you, but it seems to me that it would clarify matters for everybody, including yourselves, if we're able to do that. I am very concerned otherwise that we will leave here today with multiple versions of what we think has been agreed. And that, of course, is part of the purpose of a consultation period, is so that everyone does understand the application. It seems even the applicant or the applicant's legal representative didn't understand his own application. And I strongly suspect that if we were to take a straw poll in this room now, we would have multiple versions of what we think is to be decided. I'll leave it in your hands.
Thank you very much. Leslie.
Chair, I'm very conscious that there have been discussions with various of the parties and various conditions have been agreed, and it is possible that those agreed conditions have not been circulated to everybody. So I think it was Mr. Pickett, was it? Yes. So Mr. Pickett's suggestion that we adjourn for a short time and we come back, and I could suggest that the applicant solicitor or the applicant take us through their application, which will be found at Appendix 1, page by page, and tell us what is extant and what has been amended. That way, everybody in the room will be in the same position, singing off the same hymn sheet, understanding what is being asked of this subcommittee this morning.
Can I have an opportunity to come back?
Can we hold on a second? I'm grateful to Mr. Pickett and his comments. I agree we should have an adjournment of 15 minutes, just so we can have exact clarification of what the application now stands at.
Well, I can tell you now, the application stands as per the clarification document, which has been circulated in accordance with the regulations.
Whoa, please. Okay.
I don't mind having 15 minutes.
I think it would help to have 15 minutes so we can go through the application and just clarify to everybody the exact request.
The clarification, just to say, I've sat and listened. I'd just like to make my point, which is the initial application was submitted. There was a meeting. Took on board some of the comments in those meetings. We've discussed the matter with the environmental health officer and the police. These things do take time. And we came to the clarification document, which clarifies what we're seeking and stands. And the one point of clarification in relation to this, which was a valid point from the licensing officer, refers to my proposed condition in the clarification document. If parties want time to read the clarification document, I'm happy for them to do so, but that's what the application stands as. And as I described in my lengthy submission earlier, which subject to some points of queries and questions, I would say is clear. So that's where I'm at. If they have not got copies, it was submitted last week in advance of the hearing in accordance with the regulations. These things inevitably take time to get to a point. And the only other thing I would say, sorry, is, of course, this is a restriction down. So when we say what's the application, it is restricted down from what was originally applied for. It's not changing it and expanding it, it's reducing it.
Thank you. I think it would still help to have a short adjournment. And then, as you said, it was a lengthy presentation, and it would help if we could just summarise exactly where we are with hours and everything now, because I don't think at the moment everybody is clear as to what we're looking at. So I'd, with agreement from my rest of the subcommittee, I'd like a 15-minute adjournment, and if you could then come back with a summary, a brief summary of what exactly we are requesting now. Jack.
Chair, would it help if during this recess that we prepare a very quick document of the conditions that are now proposed? These conditions have not been agreed, but these are the conditions that are now proposed. Okay.
And can that be copied and circulated?
That'll be circulated to everyone. I'll come and speak to you.
Thank you. So we'll have 15-minute adjournment.
Chair,
yes.
if I could say,
yes.
When Mr. Shield comes back to confirm what he says is in his clarification document, I wonder whether it could be cross-referred to the original application, which we know has been amended. So that way, everybody in the room will know what is going forward, what is your proposal, and we're all then singing off the same hymn sheet.
Thank you. Microphone, yeah.
I'll just give clarity to one aspect of this. It's not so much, we have seen the clarification document, we have read it, so let's put that to bed. What isn't clear is whether it's it calls itself a clarification document. If it then amends the application, it's not a clarification document. It's an amendment document that amends the application. So it's misnamed at best. And then, of course, it's been further amended. One of the reasons that it was needed is because it appears that there's a red line exercise going on in the background on the original application. And taking your legal advisor's point there, this is one example, isn't it, that the wording to extend the entire licensing area to the red line and as licensed area, and then to say the licensed area is not subject to the restrictions of outdoor events, quite obviously gives rise to a question. Well, then what's the purpose of having any restrictions of the 10 events and so on and so forth? So we need to know as much as we need to know what the clarification document amends, we also need to know what is taken out from the original application, because anything that's in the original application that isn't explicitly referred to in the clarification document, by inference, survives the clarification document amendment. Do you see my point? That's largely what's given rise to such confusion, because the clarification document improves matters, but it doesn't improve all matters that have given rise to the residents. That's why it's as much to know what's going on in the red line exercise of extracting things from and removing things from the original application, as much as it is to understand what the clarification document adds or amends.
Thank you, Mr. Pickett. I think we will have a 15-minute adjournment. If we could come back with a document that hopefully clarifies all the points and at the same time is brief, so we don't all get confused as to what is proposed, that would be helpful. So I'll adjourn the meeting now until 10 to 12. Thank you. Thank you. We're just having the item printed out so we can all see what is being proposed. But in the meantime, I think we've got any more questions from the public at the moment of the applicant before we go ahead, and then we can come back to you. I've got a question online from Councillor Adam Boyden, though I would say, Councillor Boyden, it has to be a question, not a statement, because you're not registered to speak. Is he there? Okay, perhaps he's in the kitchen. Okay, we'll come back to Councillor Boyden. Can we go on to the responsible? What I'm going to do with the running order here, I propose to bring to the responsible authorities, the police, environmental health, but then bring the parish council up the table to the third one. Is that all right with you? So we'll go straight to the police.
Good morning. I'll introduce myself. I'm Nicola King and I'm the police licensing officer with a remit for the South Somerset and the Mendip area of Avon and Somerset Constabulary. So you will know that we've obviously based our objection on the original application that has been submitted, had sight of the clarification document, unfortunately wasn't involved in the pre-meeting that had taken place. So I will deliver our representation as follows. I don't intend to read it word for word. It was a very long representation that was submitted. So I will just try and go through it and give the relevant parts that I feel are appropriate at this time. So we gave an overview of the background of the premises, purely because of, obviously at that time, the premise license holder was still Butcombe Brewery, with the DPS being obviously a tenant that was there. So the overview that's in that representation does relate to that. And the purpose of that overview was to ensure that details was given really about the interaction that the police had taken that was really not supported by the brewery at that time. We'd had a lot of communication with the brewery and they were feeding us a lot of intelligence, but they failed to act upon anything. Having looked at the application that was submitted, can you just bear with me? I just need to turn the fan off because it's affecting my contact lenses. They're drying out my contact lenses. I know, it's so hot. She set me up to fail. That's what it is. Thank you. Sorry about that. So yes, obviously there'd been a lot of issues at the premises. The police had done a lot of work at the premises. Action plans were implemented. They had failed. whatever was put into place was failed by the current DPS. It was only, 10, as I alluded to earlier, 10 months of trying to sort out the premises, trying to work with the brewery. And at that time, there was little support from the brewery in the police enforcement that was taking place at that time. In fact, one section of my representation, I do allude to the fact that we'd actually received a phone call from the brewery themselves to say that the DPS at that time was taking and dealing drugs, and there was a significant risk of an issue taking place at the premises because there was a £25,000 drug debt that needed to be collected. That came from the brewery, but yet again, obviously that threw the police into quite an emergency situation, created quite a lot of work. Visits had to be made. We had to ensure that the public were protected. But the premise licence holder, again, failed to actually take any action in respect of that. Bringing us up to the present time, whilst the premise has appeared to have traded without an issue, there are obviously still some conditions on that licence that were not being complied with. I actually visited the premises myself and spoke to the new DPS that was at the premise. One of those conditions was around pub watch. They obviously wasn't involved in that, but now I believe after our visit, you're now signed up to pub watch. But I just think this shows it's just a concern of the police that even though we've got new people in there that obviously are looking to change the business, there's still conditions of that premise licence that are not being enforced by the premise licence holder. Obviously, we've dealt with the premise recently in respect of complaints for drink drivers. We obviously spoke to the DPS. We gave them some options that they could take, and they've taken that on board. And I do believe that that issue has now been dealt with and that no further issues are being experienced. One of the main issues with the application, I believe, is the use of the outside area and the issues that brings to the sort of the village, the neighbouring properties, and how that area has been traded before under Butcombe Brewery. Obviously, there's been significant issues with noise nuisance from the premises, the smells of cooking, the poor planning, where there'd been previous events, we'd asked for plans, they hadn't been forwarded. So there was lots of issues that were taking place there. And it's nice to hear that there are plans for the premises in the future. It was disappointing that actually after undertaking a lot of action with the premises and speaking with the brewery in respect to it and the action the police were going to take, because the police were actually going to apply for a review of that premise licence, that we decided to work in partnership with them and support them to actually remove the tenant from the premises by way of obviously going through the court process. Disappointingly, when the application was made, they didn't approach the police, as we had obviously given indication that we would like to see additional conditions added to the licence when the existing DPS departed to enable the promotion of the licence and objectives, and also to enable Butcombe to control the premises more effectively. I did have a conversation yesterday with the solicitor for Butcombe, and we obviously discussed the application and some of the previous issues. And we also obviously discussed verbally some conditions that the police would probably like to see. Those were actually drawn up. They have been obviously spoken with the solicitor this morning first thing in respect of them, and I will run through those conditions for you, so that these are the conditions that the police propose are attached to the licence to enable the promotion of the licence and objectives.
Would it assist if, as at the end of each one, if I say yay or nay, so that you know immediately? There'll be more yays than nays.
12.
Yes, okay.
There shall be a maximum of 10 event days per year, which shall include the use of the marquee in the outside area. I believe that has been clarified, but obviously there was some confusion when I looked at the documents last night when I drew these up.
Yay. Sorry, I'm now up to speed. I've got the document in front of me.
Thank you. So, for the prevention of crime and disorder, the police are proposing the following conditions. The premises must install and maintain a comprehensive surveillance system to the satisfaction of the police and the ICO guidelines. The ICO, for your information, is the Information Commissioner's Office. The system must be maintained in full working order and recorded at all times when the premises is open for licensable activities. The correct time and date must be generated on all recordings, which must be retained for a minimum period of 31 days. Recorded images must be of evidential quality. Copies must be made available on request to the police or authorised officer of the licensing authority. If the system is inoperative or faulty for any reason, steps must be taken to repair or replace the equipment within 24 hours. A data controller who is conversant with the operation of the system must be available at all times when the premises is open to the public and be able to provide police or authorised officer of the licensing authority recent data or footage with the absolute minimum of delay when requested. Management, storage, giving and sharing of data recordings must comply with the general data protection regulations at all times.
Yay.
A bound or electronic incident register will be kept and maintained to record all incidents occurring on the premises or outside and associated with the premises. Records will be made available to the police and licensing authority on request, and records will be kept for at least 12 months.
Yay.
A bound or electronic refusals register will be kept at each bar and used on the premises to record instances where any sale of alcohol and proxy sales to a patron is refused. This will also include refusals to persons who are intoxicated. Records will be kept for a minimum of 12 months and will be made available to the local authority, police and trading standard officers upon request.
Yay.
The premises will operate a Challenge 25 policy whereby anyone wishing to purchase alcohol that appears to be under the age of 25 years will be asked to provide a photographic identification, for example, passport, driving licence, pass card. Challenge 25 posters will be displayed.
Yay.
All persons involved in the sale of alcohol will receive training on commencement of employment with regard to preventing the sale of alcohol to persons who are under the required age and proxy sales. This training will also include illegal drug use and refusing sale of alcohol to persons who are intoxicated. This training will be documented and signed for by employees to acknowledge that they have received this training. All employees will receive refresher training every 6 months. Records must be made available for inspection by the police and licensing authority upon request.
Yay.
A drugs and crime prevention policy will be put into place and retained on the premises. Full cooperation will be given to any drugs initiatives undertaken by the police and the licensing authority. A record will be kept of any searches undertaken and items seized, and records will be made available upon request to the police or authorised officer of the licensing authority. A copy of the policy shall be forwarded to the police and shall be refreshed 6 monthly by the premise licence holder.
Yay.
The premise licence holder will operate a zero tolerance policy in relation to drugs at the premises, and all staff will receive training with regards to this policy. Drugs seized by staff will be securely stored until they can be collected by the police. A copy of the policy shall be forwarded to the police and shall be refreshed 6 monthly by the premise licence holder.
Yay.
External services for the sale of alcohol shall cease at 2100 hours, 23:30 for weddings, except for event days when the service of alcohol shall cease at 2200 hours.
No.
The event, which attracts more than 500 people at any one time, shall require an event management plan to be produced and retained at the premises. The event management plan shall include a traffic management plan and also take into consideration the Purple Guide or similar guidance, and will be made available to the police or licensing authority upon request.
Yay.
No event shall have over a 700-person capacity.
Yay.
A risk assessment shall be drawn up by the premise licence holder, designated premise supervisor, to determine the number of SIA door staff that should be employed for each event day opening. The risk assessment shall be provided to the police if requested. Any risk assessment shall be subject to change in consultation with the police.
Yay.
Public safety. Vehicular speed limit signs 5 miles per hour will be placed in strategic locations around the site.
Yay.
All outdoor areas shall be adequately lit at all times when they are in use.
Yay.
Vehicle movement shall be controlled when the outside area is being used for event days.
Yay.
The area outside of the premises shall be adequately protected by way of cones or similar when the premises is to host event days which attract over 500 people, to ensure that access to nearby properties is easily available to residents, families and any other medical providers.
Yay.
Those are the proposed conditions of the police. I believe that there's probably one that is not agreeable, and that obviously relates to the external services for the sale of alcohol. We would stick by that. We think it's important to have that. It could obviously, it will affect the neighbouring properties. If it was continual noise coming from that area is big outside. We could have obviously a lot of people in that area. So we will stick with those proposed conditions that we're putting forward, sir.
Thank you very much. Did you want to clarify the one you said no to?
Yeah, I think it's kind of covered in the other areas, but I'm sticking with essentially it's the midnight for the marquees.
Yeah, to me, the bar's open inside at 1 till 1 o'clock. The marquee outside is open till 11:30. So you're going to get people tracing through the car park internally. So that causes more of a risk to me than having it outside. But 9 o'clock on the external bar in the garden, I think, is acceptable.
So it just goes back to the marquee terminal out again.
Thank you. Before we proceed, does everybody want just a couple of minutes to read the paper that's been put round? I'll just give you all 2 minutes. Some of you might have been reading it already, but I'll give you a couple of minutes.
Chair, just while the people are reading, just a question to the legal representative and to the police. That particular condition, what does it actually read now?
Which one, sorry?
External services for sale of alcohol will cease at 2100, except for event days when the service of alcohol shall cease at 22. You said no to it, and then there was some came back, so I'm not sure whether or not what's been agreed on there.
Chair, my understanding is that it's not agreed and therefore it's something that must be determined by the subcommittee.
Fine, thank you.
Yes, thank you.
Chair, Councillor Adam Boyden is back online.
Okay, we'll move on. Before I do questions, please, I think Councillor Adam Boyden had a question. Councillor Boyden, if you could make it a question and not a statement, as you're not registered to speak in that respect. Thank you.
Okay. Hi, thank you, Chair. Yeah, my question, it may have been partly superseded by the changes, but it's still mainly possibly valid. The applicant earlier stated that they didn't believe that they would be causing a nuisance with what the changes they're applying for. Can I assume that there's not been any commissioned technical assessment of the noise impacts of the changes of the timings and the location of music late at night by any noise assessor? And I'm assuming that there hasn't been any monitoring of existing events or the noise levels at surrounding residential properties during those events, so that we could work out how loud things can get. And the residents have their lived experiences to draw on, but in the absence of any technical assessment, what is the applicant drawing on and leads them to conclude that there would not be any nuisance from these events? Thanks.
I'll ask Sam to answer that about the practicalities and the specifics of it, but the existing authorisation allows 3 external events. Admittedly, we're effectively asking for another 30 minutes, but there has been checks and balances done, which Sam will go through, because they've held events and done some checking in relation to the matter, and have done some recordings, etc., for themselves. But I'll ask Sam just to detail that, so it isn't that we're going into this blind.
So yeah, recent wedding, we had a live Michael Bublé tribute act. They chose their entertainment for the evening. So I walked around the external areas as would be in a noise management plan. I know it's only on a phone, but it's monitoring sound levels. So the traffic was about 87 decibels. The noise from the building was just around the 63, 64 mark. But it's not until you kind of come across the bridge. I mean, the sound of the river actually deflates any sound from the music. In fact, you can hear more from the garden in terms of children coming. You kind of come around through the garden and up the metal staircase to the rear of the building. And as you come around the side of the building, that's when you kind of get the full impact of the kind of music from upstairs. But we still had diners on the top terrace. It wasn't too loud for them. So yeah, we've done a couple of checks. Yeah, we've held 30 events so far this year. Apart from one on the 24th of June, I think a comment was made on Facebook. That's been the only kind of thing I've heard from it. We've had no other people ringing in. We've had nothing from authorities in that respect.
Thank you. Does that answer your question, Adam?
To some extent, but it's not a professional assessment. But yeah, thank you.
Maybe I could add a bit more information
to
that. I can confirm there hasn't been any technical assessment of the noise, nor have the Environmental Protection team carried out any assessment of the noise from events, primarily because we have not ever received a noise complaint about the venue, so there's been no recourse to need to go out to assess any noise impact from the premises.
Thank you very much. We're jumping about here, but we're moving on to questions of the police. Sorry, yes, sir. Do you want to come up to the microphone?
Could I just ask people to identify themselves? Sorry, I'm not sure who the gentleman who spoke before the break.
Sure, yeah. Mike Benson, neighbour. Just to say that we wouldn't expect any complaints at the moment because the existing conditions are in place that require doors and windows to be kept closed. It shows that the existing conditions are effective. Thank you.
Thank you, Mr. Benson. Right, questions of the police authority.
Yeah, thank you. And comprehensive conditions, and I think there's only one you agree that. I mean, you brought up the history earlier, and obviously I appreciate why you're doing that because it's still the same premises license holder. So, and I think you talked about, did you say you had some idea of drugs being sold by the landlord? What I can't understand on this one, and correct me if I'm wrong with how licensing law works, but I thought I was pretty au fait on this. But you had a DPS who theoretically, I know they've got a tenant, but in a normal occasion of say, wouldn't that DPS be removed? as DPS, or alternatively, couldn't you call for a review of the licence and threaten to take the licence away if the DPS wasn't replaced? And if it was that serious, and you had all those issues, and I've read every single representation here, which took me a long time. Why did you not do that? Surely it would have been the easiest thing to do.
Thank you. In hindsight, it would have been the easiest thing to do. At the time, we were obviously working in partnership with the brewery. And we were informed at that time that if the police removed the DPS from the premises, it would make it very difficult with the court action that was being taken to remove his tenancy. That if we actually removed him and he wasn't in control, it would make it difficult. So then an agreement was made by the police with the brewery that we would support them to remove him through the court. We wouldn't apply for that review of that premise license. Unfortunately, the whole process, because of obviously, COVID and issues with changing businesses, it took a lot longer than was anticipated. But in hindsight, the normal process would be we would call for a review to remove that DPS from the premises.
Apologies, I left my mic on, so hopefully everybody heard that. And going forward, then that could have happened really quickly. And if you'd had the review of that premises, it could have been closed, which would have solved the issues that you're having.
Yes, I agree.
Thank you. Any more questions, Marcus?
Yeah. Thank you. There's one other question, actually. Maybe as police, you can clear this up, because it's been talked about a lot in the representations about drinking and driving, etc., etc. And I've looked at, obviously I've not read the actual act in full detail, but I've got the, I flipped through the act, but I've got the revised guidance 2018. I've got the one on here from 2023 revised guidance. And at what point, and the spirit of the act when it comes to crime and disorder, I don't think was necessarily had drink driving in all the guidance. I haven't seen drink driving mentioned once. Talked about excessive alcohol and refusing things. At what point does the police think that drinking and driving is a crime and disorder problem for licensed premises?
I don't know whether we would link it to crime and disorder, but we'd certainly link it to responsible trading of that DPS, obviously drink drive, if they and only then if they are serving to known drink drivers. If they know someone is drink driving and they're consuming 5 to 6 pints, that would be irresponsible of that DPS. And that was obviously, we would take that that action then against that, and recently have taken that action in respect of an issue that was raised at the premises. And I believe that after that action has been taken, that issue no longer isn't a problem there.
Okay, thank you. It's just I'm just looking at the full licensing objectives on that. That's where my question's coming from with regard to that point. Thank you.
Thank you.
I'll leave it as it is. Thank you for your input.
Yeah, Marcus again.
Yes, sorry, and so apologies, everybody. I appreciate time's going on, but I do believe this is worth getting this decision right. And if it takes a bit longer, so be it. With regard to the conditions that we're all agreed to by one, let's pick one. Say hypothetically CCTV. Say there's an incident, turns up, but of course CCTV is bound to, not saying, CCTV is not working. Obviously, it's, a rural club, trying to get it mended in 24 hours might be more difficult. You turn up, as for the CCTV, it's not available because that camera's not working. The hard drive's packed up, or I don't know, an act of God or something. At what point, what action would you then take? I mean, would you then suddenly turn around and call for a review of the license, or how would that then work if some of these quite excessive, not excessive, that's the wrong word, comprehensive conditions were breached and you were known they were breached?
Sorry, it's obviously an offence under the Licensing Act to breach those conditions. So obviously, we would obviously inform them of that breach at that time. We would inform them that if they continued to serve alcohol breaching that condition, they would be reported for that offence. We would deal with it in that way. The other options that would be open to us is if it was obviously an issue that was being raised continually, we would apply for a review of that premise licence.
Does anybody else have a question of, yes?
Just a couple. So the current tenant went in earlier, 2022 after the eviction, and you've been down how many times to the site?
Me personally?
Yeah.
I've been down to the site once. But I don't do regular licensing visits to licensed premises. I'm a licensing officer that represents the police for an area that has 1,500 licensed premises.
Okay, but you're the licensing officer for this pub, yeah?
I'm the licensing officer for the area, yes.
Okay, so DPS changes, new DPS in, you've got this history, but you didn't visit or speak to the new DPS at that time or afterwards until after the application was lodged?
That's correct. That local visit should be undertaken by the local police neighbourhood team. When a new DPS goes in, the application will come to me and we will obviously check to make sure that they've got no relevant convictions. There's no traces on our police systems. If those are negative, it's handed to the local neighbourhood team to deal with.
Do you know if the neighbourhood team went down?
That would be me, and no, we did not.
Okay, no criticism, to make it clear, no criticism. And just on drink driver, which I think one of the councillors has picked up about how much it's relevant to the licensing objectives in this application. But in your representation, you talk about drink drivers, and you mentioned it again. But when you went to visit and you talked about this, there was one individual mentioned, and this was discussed with you. Have you taken any action, or the police taken any action around that alleged drink driver? Because obviously the tenant, the DPS, can do certain things, but can't take car keys off, can't arrest someone, and can't seek to breathalyse them. So has any action been taken in that regard?
We visited the premises, we spoke to the DPS, we know who the drink driver is, and so did the DPS. And I think it was brought up at a meeting that everybody knows who this drink driver is. We spoke to the DPS and gave them an option of they could either speak to the DPS themselves, or we, the police, would attend the drink driver's address and speak with them in respect of obviously them committing an offence. At that time, the DPS decided that they wished to speak to the person that was obviously being named as a potential drink driver, and it was dealt in that way. Obviously, there was some communication afterwards to say that they'd actually done it. Not aware of any further issues. If there are issues, then we will be attending that address. That detail has also been passed to the neighbourhood team of registration numbers for them to keep observations for.
So that's a no then. To my question, what action have you, the police, taken around potentially seeking to arrest or breathalyse this person? Actions this can't do. He's agreed what he's doing and he's done it, but you haven't done anything else.
And the intelligence has been passed over
Okay.
to the local policing team, but I don't really think that's relevant at what the police action in respect of a drink driver is today.
Okay. Just on the history, accepting that you acknowledge, I think you acknowledge that he's a good operator and there's no particular crime and disorder issues at the premises now. Is that correct? You've not got any crime statistics issues from the site since the tenant? Anything you mention nuisance, but you've not produced, you say you've had it, but yeah.
No, except for I spoke to them about a breach of a licence condition and not attending pub watch.
That's the pub watch, which I might come back to that, but yes, okay. Then I think my only other question was, we obviously in our submission talked about getting possession of the proceedings, which we started in about October 2021 and took through to April. And you seem to think that took a long time. We explained that. Do you know about the process of getting possession and the difficulties when the law provides for someone to have to go through court to get possession, and how long that might take at all, or not?
No, I don't. I'm a police licensing officer. I don't have training in that field.
Sorry,
But
that's fine.
I wasn't actually informed of the length that it would take for that process, and I think that's important for people to know.
Okay, and on informing, so in your submission, and you mentioned again specifically drugs, so this is why I talk about it. On the 8th of October, you say the brewery didn't work with us on drugs at all and whatnot, but you had acknowledged, and you write it, and you said it again today, on the 8th of October, a phone call was received from the area manager of Buckham. So the issues and concerns about drugs that the brewery had were brought to your attention as the police. And then you went on the 19th. There was a visit on the 19th, not by you, I presume, but I don't know. But what action was taken by the police following that in relation to allegations given to you from information from the premises licence holder that they were concerned about drugs? Because again, there is only so much, like taking possession proceedings, that a company can do. They do rely on the police. Did you take action? Was it passed over? I don't know, to drug squad, or what happened? If it's no, then that's fine. But I'm just trying to understand that.
I can confirm there was action taken. I think it was actually a Friday afternoon that call came in from the area manager for Buckham to say that she'd had information that the DPS was involved in drugs, and there was a drugs debt. He is £25,000 in debt, and that debt was going to be collected tonight. From that information went straight to our intelligence department, and obviously it went through our systems. All the names that we'd got for all of the people at the premises went through our system. The police actually did visit the premises that night to do a welfare check, and it was kept on file. And obviously all of that was obviously investigated by the police.
But no prosecutions, cautions, warnings, convictions, or anything like that around this individual.
Without evidence, no.
Without evidence, okay.
Well, there was no evidence. It was only the word of the area manager.
Brewery, yes.
But what did the brewery do? Can I ask, what action did the brewery take except to pass that information to the police?
We're not here for a cross questioning. It's the opportunity for people in the room to ask questions of the police.
I'll leave that point. I'll leave that point there. One last point. So the conditions that we did discuss, and we'd had exchange, then we had a discussion, very helpful discussion yesterday, and then you helpfully came up with those conditions. Save for the one point where it's a bit of a difference, client's happy to agree those. Do those address your concerns?
They do address my concerns. If those conditions are put into place, I'm hopeful that the premises will trade without issue.
Thank you. Yes, we're going off piste a bit here. I think we want to stick to this application really and not historical events. Any more questions for the police? You've been given quite a hard time. You'd like to step up to the mic, please. Just introduce yourself.
Sure. My name's Nigel Hellier, live in Walnut Close. Sorry. Yes. Question for the police. You mentioned event days. Can we just clarify now that that's not events, number of events, that is the number of event days, i.e. if there's an event that covers multiple days, they are deducted from those. That's what you mean by your clarifications, is it, please?
It's my understanding that those event days are the 10 event days proposed by the premises.
Okay, well, if you look at what we've just been distributed, it says it's the number of events. And so you could have multiple event days on those. And so I just want to clarify, does that, your stance is 10 event days, is that correct?
That's correct.
And is that your understanding?
I think
you have agreed to it, yes.
I think we've agreed to that anyway, and 10 event days is whether they're consecutive days, whatever, they all add up to 10
the conditions
days.
Agreed.
Okay, thank you very much.
Thank you. Right, we'll move on now, as long as there's no more questions, to environmental health. Richard.
Thank you, Chair. My name is Richard Allard, and I'm a Senior Environmental Health Officer in the Environmental Protection Team at Somerset Council. Environmental Protection.
Do you want to move your laptop away from the speaker or whatever?
Sorry.
Get a bit of feedback.
Is that better? Okay, Environmental Protection made a representation to the original application to vary the existing licence. We objected to that licence variation due to the removal of the conditions to control noise and for the proposal to extend the number of outside events, as well as an extension of operating hours for outside events. However, following discussions with the applicant, an additional suite of conditions to control the noise impact from the premises have been proposed, of which I am in agreement, have reviewed and which I'm in agreement with. Based on this, Environmental Protection's initial representation is now formally withdrawn. For clarification, the proposed conditions to promote the licensing objective of prevention of public nuisance are: a noise management plan shall be submitted to the licensing authority and shall outline measures to be taken to minimise noise disturbance from regulated entertainment when events are to be held externally. A person responsible for the overall control of noise shall be appointed, and this nominated person shall make regular patrols of the outside of the premises during external regulated entertainment to ensure the noise levels do not cause a public nuisance in nearby residential properties.
Chair, can I just ask on that particular one, could it be in external and internal?
Yeah, I have no objections to that.
Number 8. So any external and internal, so doing both, because it will be done anyway, so that's fine.
And finally, all nearby residential properties, as agreed with Environmental Protection in the noise management plan referred to in condition 7, the condition above, shall be notified by letter and social media at least 7 days in advance of any external regulated entertainment events, and shall be provided with a contact number for the person responsible for the overall control of noise from the premises. Thank you.
Thank you, Richard. Any questions for Richard? To summarise that, after discussions with the applicant, your objection has been withdrawn because of actions they're putting in place.
That's correct.
Thank you. Any other questions of environmental health? Marcus?
Yeah, thank you. I think that's pretty clear and quite consistent. Okay, so I think, and obviously I'm conscious as people in the room who might not know these things, so just for clarity, so say hypothetically there was noise coming from the premises and you received complaints. So one of the questions I actually have got is, what complaints have you had so far in the last 6 months? Well, since the present TPS has been there, have you had any complaints? My second question would be, if there was excessive noise from the premises and all these have been put in place, but you're still getting complaints from people, what would be the procedure for dealing with that? It's not quite a loaded question, I suppose. And how long would it take for, say, you to check the complaint, make sure that, verify, deal with the, measure the sound, come up with noise abatement notices, etc., to a full review of the license if no one's paying attention? What's the timescale for dealing with that?
Okay, in terms of complaints, as I said earlier, we haven't had any complaints from current license holder. I mean, in terms of timescales for reacting to complaints, obviously, if we had a lot of complaints regarding noise, then we have the power under the Licensing Act to review the license. I mean, timescales is a difficult thing. I mean, it's how long is a piece of string? Really, it would depend on how long it takes us to gather the evidence that we would need to be able to support a review. So that it may be that it's not every event that causes a problem. So it may take a few months to gather that information, whereas it could be if there are continuous events that do cause problems, we might be able to gather that evidence quicker. It's just, how long is a piece of string?
So it's just for clarity, really, for everybody in the room. So if, for instance, one Friday night there was lots of noise, and then you had to receive complaints, and the next Friday night there were lots of noise, also there would be, then you'd probably expedite things probably slightly quicker because you knew there was a continuing problem rather than the occasional and etc.
That's correct. Yes, we would. I mean, obviously, if we were to receive complaints, we would have discussions with the DPS as well, inform them we had received complaints, and hopefully they would listen to us and put measures in place to reduce that noise impact. But if not, then obviously we have the ability to review the licence and the Licensing Act.
Sorry, was there a question from over there? Mrs. Benson, is that right? I'm guessing.
Yeah, Sarah Benson. I live opposite the mill. Can I just confirm that condition 6, the provision of regulated entertainment within a marquee, that falls within the 10 outdoor events per calendar year?
Who's that?
I'll tell that one. It's something that we have agreed. If the conditions are met.
So those regulated entertainments within a marquee are part of the 10 outdoor events?
Yes, they are.
Yes. My second question is, if the whole area becomes licensed, we can have music, outdoor music from 8 till, I think they put 10 o'clock at night. But do we have to be made aware of that by the applicant?
We're going a bit off piste here because these should be questions for environmental health, but perhaps we can answer that one.
No, the notification is for events.
It's for the 10 outdoor events?
Yeah.
Okay, thank you.
Sorry, I think the gentleman in pink. As we call it some other colour rather than pink.
My name is Anthony Battersby. I'm a clerk of Telesford Parish Meeting. My understanding is that any change in activity within 8 metres of watercourse requires flood defence consent from the Environment Agency. Has such permission been granted by the EA? Indeed, is the EA even aware that this application, which is significantly changing the outside activities, has been made?
I can't speak on behalf of the Environment Agency. I'm not part of the Environment Agency, and I don't believe that is relevant to the licensing hearing anyway.
Sorry?
I don't believe that whether the Environment Agency have been notified in terms of flooding is relevant to the licensing objectives.
Leslie, do you want to just clarify that?
Why not?
That is correct. There are 4 licensing objectives. The EA remit does not fall within a single one of those. And it is probably likely that that question will need to be addressed through the planning regime.
Thank you. As we stated before, planning isn't part of the licensing. Thank you. Any more questions for Richard? Yes, sir. Mr. Pickett.
Thank you, Chair. Before I raise my questions with the Environment Agency, can I just, Environmental Health, just to explain why some of those questions seem to be questions to the applicant. I think we skipped questions to the applicant because, for good reason, you wanted to move on whilst the document was being prepared. The police then started, and we started down the agenda and migrated on. So I think I may be right that there's other questions that really should come back to the applicant because we haven't finished that questions to the applicant. For that reason, Chair,
sorry, I don't want to interrupt, but can I just find your representation? I'm missing it, and those in attendance giving notification to speak. I may be missing it. I may be missing it.
Well, there's 2 things here. I think Mr. Pickett is entitled to ask a question as a member of the audience.
It's on page 45 of the
as a member
agenda.
of the public, but also he is going to speak as Mike Salmon and Andrew Battersby.
Yes.
In the order.
So Mike Salmon is the proxy, or was the proxy for the Telesford Parish Meeting on the basis that this affects the parish of Road, even though the mill technically is in the parish of Telesford. And yesterday, Mike wrote to the panel and asked if I could be substituted because I was due to be away this week, but I was able to be available at short notice.
That's fine. I was just trying to find you on the list, and you aren't on, but got the later list. That's okay. I was just trying to understand and link into your rep. That's fine.
So, Chair, I don't have many questions, but could I ask questions of the applicant? We return to that part of the
I think
agenda.
I did leap ahead, so yes, I've got. no
Thank you. Question really to Sam, I think, although it's for the applicant collectively to decide who answers. Given that everything that's been said in the clarification document, correspondence you've had with the parish council, and much of what has been said today is about specific weddings and similar events outside. Why are you seeking to extend the licensed area so extensively, specifically to include the island? Because the proposed use of the island within the clarification document doesn't require a license. And all of the car park in infill areas, would it not be commensurate with your aims and objectives that you've shared with us and that we will take at face value, simply to have extended the license area to include the terrace and a temporary marquee wherever situated?
We're not amending our application in that regard, is the short answer, but I'll let Sam answer. But those are to bring it within the licensed area. So there's no argument about what's in and what's out of the licensed area. The plans show the indicative and correct positions of the marquee and the proposed bars. So we're not proposing to amend, but Sam, over to Sam.
I'm sorry, that wasn't my question. I'm not asking whether you're seeking to amend it. I'm asking why it is in its current form.
I think it just gives the flexibility of the site, because it may well be that the marquee is not going to move. That's where the wedding's best situated in terms of fixing directional. But we may get one of those beer festivals may turn into like a small car show in which half the car park can be used, segregated off with the crowd barrier, and the overflow car park is then utilised as the main car park. So it's just to give the site the degree of flexibility and able to host several different things.
So why not exclude the island, given that the Section 106 prevents its use for that purpose?
I think we've answered that question. It's for the committee to decide. The Section 106 agreement will be complied with at all times, and that is outside this hearing, but we've confirmed it a number of times now.
I understand the application. My question is not what is the application. My question is why. Why seek to license the island, which doesn't seem to fulfil any purpose that has been shared with this committee or in consultation with the residents or the parish council? There is no obvious purpose to license the island in any of the documentation. I'm asking why, therefore, you are stubbornly including it. You've said that you're not going to amend your application, and I hear you. I'm asking why.
It gives a degree of flexibility to the site as mentioned. So whether one of those is a family day, as one of those, I can't remember which point it is, but one of the maps show donkey rides and small stalls on the island, that may well be a gin cart or something very similar, or a Pim's little bar put up. In terms of the 106, Schedule 3 says any object or structure can be placed on the island with written consent of the council. So it won't be an everyday thing. It's just giving the flexibility and able to be a host of different things.
Can I just interject? I think the question's been answered, and I don't want a cross-examination as such. Thank you.
Okay. The trial you held in terms of the music that you monitored, and you said you went round with your phone, I think, is what you did. What time of day did that take place, please?
7:30, between 7:30 and one about 8 o'clock.
7:30 to 8 p.m.
Yeah.
And what level was the music being played? Can you describe it in any way, in any scientific way, the decibel level or the type of music?
Internally, it was a daytime wedding, so they had the wedding breakfast at 2, 3, so they were kind of 7, 8 o'clock is when the main kind of evening entertainment was kicking off internally. So I'd probably say it's at 80, 90% of what a disco would be, or you would expect when going to a wedding on a dance floor.
But that wasn't scientifically measured or determined in any way. That's your estimate.
No, but as a reasonable operator and with people underneath in the restaurant, we keep it at a reasonable level to be able to operate a restaurant, terrace and a function at the same time.
So that brings me to my next question, is that was an indoor event, yes?
Correct.
Those are my questions to the applicant. Chair, if I could now address my questions to the environmental health. unless you want to see if there's any other questions to the applicant before we move on. It's a matter for you. Timetable.
Have we got any, you're doing the meeting for me. Have we got any other questions for the applicant? Have we done there, I think? Okay, thank you. Yes, so you can ask a question, environmental health.
Thank you, Chair. Sorry, there is one chair, one question, Chair, for the applicant.
Thank you. My name is David Clay. I live nearby in the village. Can I ask a theoretical question here then? As the licensed area is now within the red line, and that excludes anything within the red line as being restricted by the conditions on outside events, could you hold live music events outside 365 days a year till 11 p.m. if you so wished?
I think that's a question of law and regulated entertainment and deregulated entertainment.
And I'd follow that question with, and currently, are you only allowed to do that internally?
No.
So currently you could do that.
I'll answer this question by saying we now currently, and I won't speak about previous tenant, the current tenant has complied with the law on deregulated entertainment, which we're not seeking to change, and will continue to comply with the law on deregulated entertainment. That answers that question.
But is deregulated entertainment currently only within the licensed area?
I've answered the question.
And the licensed area is internal only at the moment. And you're looking to extend that licensed area. Sorry, I'm not the only person who's confused about this.
Yeah, I think we've answered the question. Leslie, do you want to add anything, or you? Yeah.
Deregulated entertainment will take place within the licensable area.
Okay, further question is the licensed area internal only at the moment with the current license?
I have to say, I think I disagree with the interpretation on the red line or not red line. It's regulated entertainment, licensed premises, and there are various exemptions which operation out in the outside area is covered by deregulated entertainment under the Live Music Act 2012. We will comply, what I will say, we will comply with the deregulated entertainment law, Live Music Act 2012. It then comes into a, if there's a belief that we're breaching that at any time, investigation action, we will not be doing that. And we have not done that.
I mean, deregulation just applies to live and recorded music.
Absolutely. And I'm not trying to be contentious. I'm saying the law is the law. We comply.
Okay, I think we'll close that question now because I think they said they'll comply with the law, which is all we can say on that.
I'm sorry, I didn't get an answer to my question about where the current licensed area is on the current license. I'm just a layperson here. Is it just the building itself as it currently stands? Or you're not going to answer that question? Sorry, I'm just a layperson. Excuse my ignorance on this. You don't have to be rude to me.
Within the licensing act.
Sorry?
Within the licensing act, the deregulation area has included beer gardens. But in answer to your question, the current license, the licensable area is the building itself.
Thank you. That was my question.
But we are talking about this application.
Thank you. Mr. Piggott, this is of the environmental health now, I think.
That's a perfect lead, Chair, into the question that I'd like to ask the Environmental Health Officer. Could I ask you to turn to page 31? Do you have the original application? Chair, with your permission, can I pass my copy of the map to the officer? So you see in front of you, it's page 31 for those who do have the bundle. You see in front of you is a map with a red line encompassing the entire physical location of this facility, yes? And that includes the car park, includes the island. Yeah. Is it your understanding that if that red line is granted as a licensing area, that unregulated events can take place in that area?
I believe so.
Yes. Can I have the map back? So as environmental health, are you concerned with unregulated events taking place in that area?
Well, the very nature of them, they are unregulated, aren't they? Therefore, we would have difficulty.
Can we just clarify? It's deregulated, not unregulated.
Sorry,
It's an important note. I know you understand, and it's the person making the objection, but it is an important distinction.
I would suggest that the reason they're deregulated would suggest that they would be acceptable to be undertaken.
We are talking about, under the law, we are talking about events, am I right in saying less than 500 people with recorded music or live music can take place as of right in licensed premises?
That's what I understand.
Yes, that's what I understand too. So I'm glad we're at one on that. Do you have concerns as environmental health if such events take place in the outdoor areas as designated by the red line on this map?
No.
Why?
Because, I mean, they, as I said, they are deregulated, so therefore.
Marcus, can you just, yeah.
Can I just, because, and if I can bring in Jackie, because you just mentioned beer gardens, because obviously I can see where we're coming from, we talk about the licensed premises and where the license actually is drawn now and where it will be drawn, but you just talked about there about the Act and including beer gardens, so in essence, that's what they've already got.
What I'd just like to say is, to come in there, is that this is an application to vary the licence, and that is what should be discussed.
Yes, and one of the variations is to extend the area, that's my point.
And that is the application, and that is for the committee to decide.
Indeed, and I'm asking the environmental health officer's input as to the extension element of this application.
You're asking his opinion whether there be a problem.
From his perspective as an environmental health officer,
And he said no, because nothing has happened as yet.
Do you foresee problems with unregulated events taking place in the outside areas that this line would afford?
I think that's difficult to say, isn't it? I mean, yes, you could probably foresee problems, but without knowing necessarily what's going to be occurring, then, you know, it's hard to say that, yes, there will be problems or not. It's difficult to say.
Well, we know what the law allows a licensed premise to hold as unregulated events. It's up to 500 people with live or recorded music within the licensed premises. And given the vicinity of the houses nearby the caravan site business that is adjacent to this facility, do you as environmental health officer not foresee that that could give rise to multiple complaints and problems occurring within the local community?
I don't think we really need to discuss what might or may not happen in the future.
Yes, could I interrupt? I was going to say that you've heard from the environmental health officer who has advised this subcommittee that he's considered the original application and as a result of discussions with the applicant, proposals have been put forward, and in his professional view, those agreed conditions ameliorate any of the initial concerns he had. It is open, as we've heard, for anybody during the operation of the business, if there are concerns, to raise those concerns with the licensing authority and possibly to seek a review.
Thank you, Leslie.
Chair, could I ask you then, is it not the panel's intent to try and ensure that the decision avoids the need for subsequent reviews and challenges to license? In other words, do you wish for it to go wrong before you seek to remedy the issue?
I think we've got to consider the application on what we've got. We can't be looking into what may or may happen in the future with it. With regard to any application, it's just not part of the application process.
And is it not part of the application process for the residents to challenge the statutory consultees if we believe that they're mistaken?
Chair, if it helps, I don't wish to steal the applicant's solicitor's thunder, but I believe he may be referring to an article by an eminent licensing QC or KC, I beg your pardon, in regard to perceived problems. And that may assist you.
I'm trying not to become involved because I do appreciate the residents, as to my applicants, the concerns, and they want, and I think your legal advice is put. I will cover some of these points in my summing up, which I will try and keep as brief as I possibly can. So I am trying to sit on my hands and understand the concerns. I don't think it's appropriate to have a discussion in relation to interpretation of the law in relation to certain aspects. You have the application, you have the licensing objectives, you have the position of the police and the environmental health officer as stated.
Thank you.
Well, Chair, if I could clarify, I am not seeking to ask a hypothetical question of what might happen. I'm asking that if something that is, as of right, permitted to happen if you approve this extension, which is that unregulated music takes place, and I'm asking the Environmental Health Officer if under consideration of my questions, he stands by the fact that he doesn't foresee a problem from those events taking place. That's not a potential what could go wrong. That is what would be granted by you moving the red line in the way that has been applied for.
I think
Chair, just for the minutes, can we just make sure that it is deregulated and not unregulated? Thank you very much.
I apologise. Deregulated.
I think Environmental Health have already said that they've had discussions with the applicant. Have agreed, come to agreed conditions and are happy to withdraw any objections. So by doing so, they're saying with the application, with the amendments or clarifications they've had. So I don't think really we need to go into that any further.
Thank you, Chair. I have no further questions on that basis.
Thank you. Right. We shall now move on to other persons who present their case in turn and call any witnesses. And we're going to start with Mr. Pickett.
Thank you for that time to gather my thoughts, Chair. Just bear with me a moment. The primary submission that the Parish Council make is that this application has changed so much since it was put out for consultation that we consider that it would only be right for this to go back to consultation. For an application to change so much, some of which has been improvements, we accept that, some of which have been mere confusion, but for it to have changed so fundamentally, it seems to me that it would be wrong, and in effect, it would have the effect of bypassing the consultation stage for you as a panel to decide on this application. And that includes my point earlier, that effectively you're being asked to navigate your way through a whole plethora of things that have and haven't been asked for, the consequences of which might not be obvious either to you or to those making representations today. It seems to me the purpose of the legislation is that the application is clear, it is put before everybody, consultation is sought, and if minor changes are made as a result of consultation, that they're done so in a clear way. That has not happened here to the point where even today, certain things have been added, changed, or further clarified. If you don't accept my point on that, if you do accept my point on that, you should reject the application and invite the applicant to remake it in a way that can be clearly understood in one way, in one document and consulted upon. If you don't agree with that, then the Parish Council, on behalf of the residents, continues to have some concerns. As you'll have gathered from my questioning of environmental health, we are greatly concerned by the extension of the licensed premises to include the island, the car park, the allotment, and all surrounding areas. And as I put to the applicant, it's unnecessary for that to be the case for the events that he is indicatively saying will take place. And when I say that, I'm talking about pages 15, 16 and 17 within the supplementary or the clarification document as it was entitled. Those events don't require licensing of the car park. They don't require licensing of the island. So to apply for that without giving any clarification as to what that is, except for the answer flexibility, gives us grave concerns, and they continue with us. That is combined with the fact that the deregulated events that can take place in licensing premises, and it was incredibly obvious that nobody to my left wanted to admit what the current licensing premises are, because it's quite obvious that once we understand that the current licensed premises are internal only, that deregulated events taking place in the new red line shift from being inside to outside, and they are not protected by the restriction of 10 regulated events, simply because they're deregulated events. That's our gravest concern. We also have concern with the terminal timings of midnight and 12:30. We consider that too late for the rural location that this pub is located in. It's notable that in the consultation, and I think it's right that it's an unprecedented amount of input that you and your colleagues have to consider. 53 residents taking time to write in. 100% of those raise concerns about noise. Those are not just noise from the regulated, deregulated events. That's also noise from, not just the regulated events. It's also the deregulated events, especially with the expansion into the outside areas that would come by virtue of page 31 of the application. Finally, not quite finally, penultimately, Chair, the island is a very important aspect to the villagers. It provides a buffer zone to the rest of the village, or at least part of it. It provides a wildlife refuge. And for that to be encompassed as a licensed area, we say fundamentally undermines the conditions that were agreed back in, I think, 2005. And that brings me to my final point. The conditions that exist are working. We, the residents of the village, we do want Sam and Rachel to be successful with this business, and we do want to make changes that assist with that, but not ones which go so far that aren't even explained by the immediate plans that they or Buckham have. In other words, it enables them to do things that way beyond what they say they want to do. If we can take at face value what they say they want to do, then they should amend the application to reflect that and no more. So whilst we do want to work with the applicants, even in its current form, the Parish Council and the Parish Meeting for Telesford continue to object to it, and we ask you to reject it.
Thank you very much. I'll let all the other persons speak before we ask questions. Unfortunately, I've got to go back one step again because Councillor Boyden wants to ask a question of environmental health after he thought he could relax. Councillor Boyden.
Okay, thank you, Chair. Apologies, I missed, I think, the chance to intercede before. So question for environmental protection. So 2 questions really. First one, can any noise monitoring be required by condition during outdoor events or music when there's music in a marquee, either on the premises or at residential properties nearby, to make sure that the council then has the noise data required to address any complaints and to keep the noise down within reasonable limits during late night events? Can a condition be imposed like that? And also, secondly, maybe it's to clarify on which days you're happy with music from events and outdoor marquees being at what times of the evening. It's a bit confusing with the licensing hours and 2 conditions covering that. What times are you happy with music being played outside or in a marquee outside What times are you happy with in your response? Thank you.
Okay, to answer those questions, so in terms of a condition, there is already a proposed condition that there would be a person responsible for the overall control of the noise. They will carry out regular monitoring of the site around the boundary of the premises to ensure that levels don't cause a public nuisance in nearby residential properties. So that's in effect. I mean, admittedly, we could look to amend that condition to require noise levels to be noted or records to be kept of those patrols, and records to be noted of music levels, not necessarily to record noise levels, because we aren't setting a noise limit within this application. And in terms of the times, I'm in agreement with those that are proposed in the application.
So is it possible to clarify what those times are, please? Monday to Thursday, Friday and Saturday, and Sunday, because there's 3 different times.
Shall I read those out from the paper there? Sunday 11 a.m. to 11 p.m. Monday to Thursday 11 a.m. to midnight, and Friday and Saturday 11 a.m. till 1 a.m.
I thought it was amended in these.
So it does conditions 2 and 6 amend those for music outside and marquees. I'm just wanting to clarify what those mean in terms of when the music stops each day.
Sorry, music from outdoor events shall cease before 10 o'clock. Is that correct?
Yes, but there is then the caveat around the marquee finishing at midnight. So, yes, it's in that document. It stands as in that document.
Just Adam can't see the document.
No, I've seen it, but so the music stops at midnight unless it's Sunday. Is that correct? In which case it stops at 11 or 10.
No.
So it's a bit confusing, that's all. And I want to make sure that everyone is aware exactly of what's being permitted if you go that way. Hence my question. As I read it, Monday to Thursday, Friday and Saturday, the music stops at midnight and the events end at 12:30. Sunday, the music stops at 11 because the licensing hours end at 11. Am I correct?
Jack, do you want to? So I put you on the spot there.
It should be clear, shouldn't it?
The licensing hours.
I think it's your laptop next to the microphone.
Just dead, mate. Right. The licensing hours, as stated in the application, or for the live music and recorded music, are as in the application, which is Sunday 11 to 23, and live and Monday to Thursday 11 to midnight, and Friday and Saturday 11 till 1. Within the conditions that's being proposed, and these conditions have not been accepted at this stage, the conditions that's been proposed is that all outdoor music will cease at 10, with the exception of the marquee. And
I think your mobile phone or the technology.
No, I think it's feedback from the speaker. If we can mute Adam, then it will solve the problem here.
they need to mute.
He's muted.
He's muted. That's better. No.
Perhaps you could come to this.
If it helps. So we have the indoor hours, which are very clear. We have the general outdoor hours, excluding marquees, which are clear. The marquees say midnight for the last time. I think what the councillor may be getting at is that actually Sunday indoors says 11 o'clock and we're seeking Sunday outdoors till midnight. If it assists, if the marquee is used on a Sunday, it's adding more conditions, but if it assists, if the marquee is used at an event on a Sunday for a function, terminal hour is 2300. Other than that, what we've got, what's in that document stands. Does that help A, the council, and B, the committee?
Thank you. You clear, Adam?
It helps clarify, yes, because I think people were under a different impression. I was. Thank you.
Long way. Thank you very much. Yes, young lady. Who are we asking a question of? I'm sorry, I'm a bit confused.
Sorry, my name's Jill Bliss.
You turned your mic off again.
I think the microphone, is it green? Press the button, press and hold.
So just to clarify, this is Jill Bliss. Are you speaking at your next speaker? Is that correct? Are you asking a question?
I'm asking a question.
Of.
Yes. It's.
Who are you asking a question of?
The applicant then.
Okay,
Yes.
well, I
Well,
think
I'm
we've
just
already-
going on from there.
That session's finished. I mean, the next person to speak is yourself, to give your presentation, because we're on to the other persons
okay.
now. All right?
Well,
Chair, do you want the questions to me then? I came and sat down whilst
Yeah.
Adam played music. I still have some of my questions. I haven't been asked questions.
No, I know. We're going to do all those at the end.
Oh, okay.
Once every other person has spoken, we're doing questions of the other persons then.
okay. Okay, I'm a resident of Road, and so I wanted to come really because I felt very few residents probably would be able to come. And the impression I think from the villagers is that we've just been sidelined on all of this. And I noticed that in the applicant's talk is almost as if, although the mill is called the Mill in Road, and yet it seems like very little is being addressed to actually what will happen in Road about all of this. And Road is a village, quiet country village, lots of families, not just old people, but lots of families, children. But I think as a quiet country village, people are living there and making a choice to live there because it is peaceful and tranquil and has nature. Now, this does not really, I suppose, come into what the criteria is that we can object to on this. But it's actually what I think the villages are as talking about when we're talking about the noise coming and things. It's actually as if that the applicants think they have come to somewhere where there is nothing, where it's empty, so they can fill it up. Actually, there's a lot of things going on in Road, and it's all about the life of the villagers and the life that they have at the moment around being a village life and a peaceful, tranquil in the evenings a lot of the time. It's not that things don't go on because things are arranged to go on. But I think from the majority of the villagers, the worry that the application is so extreme that it is it's working at the moment. And you know, the villagers have really been welcoming of the mill and what they wanted to do there. But I think I just wanted to speak out for the villagers. I know lots of other people are going to talk about businesses. They're going to talk about other things that come up in the criteria. I wanted to just have somebody's point of view from Road Village that we seem to the lost my train of thought. It seems that the road was forgotten about, in a sense, not even contacted most of the village. So there was a real scramble at the end. You say there are 53 people. I think had there been more time and more people, because there are still people on Facebook saying, what is this about? We didn't get to hear about this. And so that's why I want to say, I won't say any more, but that's why I wanted to come and support everybody was here and to actually say the village is worried about this.
Thank you very much. Michael Benson is the next speaker.
Give my creative writing at the start of this. Okay, imagine it's 7 p.m. on a sunny Friday evening and you and your partner have arrived in Road. You are staying at the Barrow Farm caravan site, enthused about by a friend who stays there every year and who always raves about its rural setting, surrounded by nature, away from noisy roads, and on the edge of a stunning village. You are looking forward to a relaxing weekend. Tomorrow, you also hope to enjoy a pint and a meal at the Mill Pub, which looks so inviting on the opposite side of the river, just 200 metres away, maybe less. Then it starts, amplified voices. Is there an event on at the pub? Perhaps a wedding in the marquee you spotted earlier. You cross your fingers and hope that it won't be too loud and go on for too long. For now, it's not too bad. 9 p.m. and the music has started. It sounds like a rave more than a disco. The bass is thudding across the field, and you can hear every word of every song. 11:30 p.m. and it's still going. You've been trying to sleep for the last hour and a half, and it's impossible. Caravans, you now realise, aren't built to be soundproof. You have the windows closed despite the hot weather, but it's made zero difference. Surely it will stop at midnight. Maybe now it will. I'm not sure. But in this one, I've said now it's now after midnight and still going. If anything even louder than before, you regret coming to Road, as this is intolerable. How much longer will it go on for? One thing's for sure, you'll be leaving first thing in the morning. And when you get home, you will definitely write a stinking review to warn others what to expect if they're foolish enough to stay at Barrow Farm, which is our house. So, some history. Back in 2005, in the days when social media was less impactful, there were numerous events at the mill with amplified music. They were investigated and proven to be a public nuisance as they had a negative impact on the lives of many Road residents. They also frequently caused our caravanners to leave prematurely, on more than one occasion in the middle of the night. It was a situation that caused my wife and I many sleepless nights and considerable stress. It was impacting on our livelihood, and we felt we had no control of the situation, despite continually asking whoever answered the phone at the mill to turn the volume down. When events were held on consecutive nights, the negative impact and our stress levels understandably increased, as we and our caravanners became sensitised to the noise. So fortunately, our nightmare ended when noise level investigation by Mr. Blanksby from Mendip Environmental Health Office resulted in the current licence conditions being imposed. These measures, which the applicant now wishes to remove, were imposed for good reasons, in order to promote the prevention of public nuisance from events held inside and outside the premises in a noise-sensitive area, by limiting the number of occasions when entertainment may be provided and by mandating noise mitigation measures which require all external windows and doors to be kept closed during music and entertainment events during either regulated or deregulated events. The conditions, which are as relevant now as they were in 2005, have proven to be both proportionate and effective. They have protected ourselves and our business from the adverse impact of late night noise, whilst enabling the mill to be a viable commercial business for many years. As such, I urge the committee to reject the applicant's request to remove them. I also urge the committee to reject the applicant's request to extend the premises licence to include the entire external curtilage. This is important as any external area that is licensed may then be used for unregulated outdoor events with amplified music. I believe the exit was already addressed it. Somerset licensing policy, section 2.3, states that noise from music is a special area of concern. And 2.3.2 advises the applicant to include in their operating schedule detail as to how they will prevent noise from the licensed premises becoming a nuisance. In my view, this has not been done. Instead, the application actually removes most of the existing mitigation measures, especially for deregulated events. Yes, they mention a noise management plan to minimise noise disturbance from regulated external events, but this plan has not been shared, so it's impossible to evaluate the effectiveness or acceptability of the measures. However, there is absolutely no consideration or plan in the application for noise management and mitigation of unregulated external events, which is the classification sought for events held outside in marquees and amplified music until perhaps. I'm not sure, that might have changed now. So for internal events, yes, the clarification document does offer to keep windows and doors closed for regulated indoor events, which is good. It's where we were. However, it does not offer the same mitigation for unregulated indoor events. As the potential noise levels are the same for both unregulated and regulated events, the same mitigation measures must surely be necessary. Next, I would like to highlight my concern. This license variation request is an attempt by the applicant to change the nature of the mill at Road from a country pub and restaurants into a party venue, whether that's weddings or other celebrations. The application has been made very quietly in the summer in the hope that it would not be noticed and opposed. I also suggest that this is the reason the applicant has deliberately not worked in partnership with other parties as required by Somerset Licensing Policy Section 3.1.1. In particular, there has been no communication prior to the application with Road Parish Council or with neighbouring residents and businesses, including ourselves. That's the end. Thank you.
Sorry, Sarah Benson. I didn't put my mic on.
I guess you don't want to hear me repeat all that, but I do want to say that back in 2005, my husband and I were here in the same situation. Our farm is adjacent to the River Frome and opposite the mill. The music we experienced back then, particularly outside music, was intolerable. We had caravans leaving in the night. Our caravan site has run successfully now for the last 19 years. It is a 5-van certified location caravan club site. It might seem piecemeal to you, but it's been a successful business, plus our holiday cottage. Caravans say to us, so peaceful and tranquil. Sometimes when the mill has had an event, they say, oh, it was a bit of an event last night, but it was only the one night, so that's fine. Looking at this application, which basically means if the whole outside area is licensed, we will be exposed to the potential of outside music 365 days of the year, and 10 external, definitely 10 external big events with marquee weddings, which basically we might as well be guests by the noise which will be impacted with. Back in 2005, the Environmental Agency actually were really helpful, and they subsequently put the current conditions on the licence. In my view, the tenant at the time, who was there for a number of years, he ran the mill successfully. He ran wedding events, he ran parties, he had christening parties. They were all internal, and he adhered to the conditions. And that is why there have been no complaints for the last 18 years. It has been a compromise for the residents, us, and the mill. It fills me with absolute dread that we stand here years later to go through all this again. As I say, our caravan site might seem piecemeal, but a few years ago, the Caravan Club estimated that £50 a day is spent per van on the local economy. Having run the site now for 19 years, I've estimated that we have probably contributed over 1.2 million towards the local economy, ironically including the mill, the other pub, the cafe, the post office, the farm shop, and the wider area of Frome. That seems probably piecemeal, but it's a contributing factor to the local economy of Mendip. If we have music, particularly outside music, at the same levels we had back in 2005, I feel that what the mill are requesting now will be 1,000 times worse than what we experienced then. We will see our caravan site and our holiday cottage business absolutely destroyed. It will only take a few reviews regarding the noise to decimate our business. Being 5 stars now will make no difference if they've had a horrendous time with music keeping them up. That's what will happen if this application is approved. No noise baffles or buffers will prevent the level of noise you get from live music outside. We all know what a marquee wedding is like. You hear the music for miles. This application is causing a huge amount of stress, not just to ourselves and our concerns regarding our business, but also to our neighbours and the other residents of Road as to how they will be affected. Please listen to us, the residents, the police concerns, that we can live alongside the mill without undue stress, disturbance and noise. And I feel we still lack clarification on the times of the external events and also the deregulated events, which could still run every day of the year if the pub so wished them to. That is all I have to say. Thank you.
Thank you very much. David Clay.
Thank you. I'm a resident of Road. I live on Lower Street. In fact, I'm Sarah and Michael's next door neighbour. And I'm going to state that we have the same problem. I've lived in the property since 2005. There were some issues with noise. The current licence has resolved that. Now, this new application leads to further concern about noise and uncertainty about how much noise, how many days of the year, and to what times, both regulated and unregulated. I mean, I'm going to keep it brief because it is the same sort of thing, but I have seemed to have added in the last couple of hours quite a few things here that just add to the uncertainty. So there's been an agreement with the police, I understand, in this meeting today, that it's 10 event days, yet in the application it's 10 events. Are those events 1 day, 2 days, 3-day events? Is that 30 days or 40 days of regulated events a year outside? And then if they've got a marquee up for a regulated event, is the next day going to have an unregulated event in it? Play music till 11 o'clock at night. I have a 5-year-old child. I have a 7-year-old child. They can't sleep when the events are on as it stands. Okay, 2 or 3 days a year, that's okay, understandably. The prospect of this could theoretically be 365 days of the year till 11 o'clock or later at night would totally devastate our lifestyle in this village and everybody else's. Right? I can see you shaking your head. I'm sure it's not at me, but you could at least look at me in the eye. My children's lives will be destroyed if that happens. I'm not saying it would happen. Maybe you are great. Maybe you don't do any of that, but the worry of it. And then what if you decide to leave? What if the gentleman from Buckham who has no previous record or knowledge of what happened with the previous bad landlord, okay, maybe he leaves, goes to another job. Maybe there's somebody else there. Maybe there's somebody else sitting there. Maybe they've got a different business plan. With this red licensed area, it is just unacceptable. The license that was put in place in 2005 was there after consultation with the Environment Agency, with the other consultees, and it was put there after this sort of thing caused a problem in the past. And what you're asking is for the same thing to potentially happen again. So I'd respectively asked that this application is refused. Thank you.
Thank you very much, Mr. Clay. I think We were going to have Grant Slade speaking on behalf of Jim McAuliffe, but I think Jim McAuliffe might be online and able to speak. Come in, Mr. McAuliffe.
Hear me. Hello?
Hello. Go ahead.
You can hear me, great. Thank you. My name's Jim McAuliffe. I'm a resident of Road. I'm also a parish councillor. I'm just going back to the open public meeting back in July, and a suggestion was made then that the applicant withdraw the application and resubmit on the basis that the applicant's representative was not able to properly explain some of the, or properly respond to some of the questions that residents put to him. As it happened, the applicant decided not to withdraw the application. And obviously, we've gone through this process and a clarification document has been produced. And we heard in the first part of this meeting, there was considerable confusion around the status of the clarification document and actually some of the issues that were raised in it, some of the comments that were raised in it and how to interpret that. We took a break, which I think was useful, and the applicant was requested to clarify some of the points that were at issue and not properly understood. And I think a document was circulated to the meeting, which apparently clarified some of those issues. However, listening to the discussion and the comments since the break, every single person that has made a contribution, apart from the applicant, has had further questions of clarity about what the application actually is. And to be honest, I'm still not completely clear. Point that Andy Pickett made earlier on behalf of Road Parish Council, that the process go back to square one, the applicant go away, make a proper submission that everyone can comment on, because all of the clarifications in inverted commas in the clarification document and the document that was circulated earlier on in this meeting have not been available to villagers in Road to comment on. So I think the application, as it potentially now stands, has a limited viewing from all the people that are going to be affected by it. So sorry, that was a preamble. My main point was actually to raise an issue about traffic. And whilst I appreciate that highways are not a consultee in this process, I think that the issues to do with traffic need to be properly considered in the light of the recent approval by Somerset Council Licensing Committee of an application from Bath Rugby at Farley House, which is about 1.8 miles away from the mill. And that approval allows for up to 80 events a year at Bath Rugby. And each of those, or at least half of those, can be attended by up to 200 people. Clearly, that will generate quite a lot of traffic in the area, and a traffic management plan has rightly been agreed between Bath Rugby and Somerset Council, and that traffic management plan requires that all vehicles exiting Farley House after an event are channeled down the lane towards Road and towards the mill. And as anyone who has visited the mill knows, those lanes are incredibly narrow. They're single track, they're unlit. The road surface is not good. The road surface gets particularly poor in winter when it's been raining and potentially icy and cold, etc. And there is absolutely the possibility that a large number of vehicles leaving an event at Farley House will converge on the mill at the same time as a large event at the mill. As we know from discussions we've just had, the mill could be holding outside music events 365 days of the year, and up to 500 people. Whilst we absolutely, I think, accept at face value that the current tenants of the mill don't intend to hold outside music events 365 days of the year. The application effectively means that they can do so. And so sometime down the line, either Sam and Rachel change their mind and think that it's a gold mine to have outside music all the time, or a future tenant comes in and is not quite so amenable to the neighbours. So I think that one of the key challenges is, notwithstanding all the issues to do with noise, which are absolutely fundamental, but there are also some serious concerns about traffic management and the very fact that the location of the mill and Farley House are very, very rural. The lanes around both locations are single carriageway, unlit, and likely to be potential road traffic accident areas, in particular, given the fact that obviously both locations are selling alcohol late into the evening. So that's the comment I'd like to make. Thank you for allowing me to make that statement.
Thank you very much.
Chair, could I just respond in regard to that gentleman's comments about highways? His concerns, which were set out in his representation, have been passed on to Somerset Highways, who have responded that they will look into matters. But to date, I'm advised that nothing further has been heard from them.
Yes, thank you. I did raise it with Somerset Highways, but to date haven't had a response from them. Thank you.
Thank you very much. Next, we move on to Priscilla Thomas.
Well, a lot of this has been covered already this morning, or now this afternoon. However, I'm going to read the statement that I wrote yesterday before I'd seen any of the latest documentation from the applicants. I'm disappointed by the total disregard Buckland Brewery has shown to the residents of Road. This application gave us little notice and opportunity to object or otherwise. At the very least, surely near neighbours of the pub should have been contacted and advised that this application was going to be made. We've been here before. An earlier application to vary the licence was made in 2005 and was strongly opposed by the residents of Road, Tellisford and Wolverton. The variation was granted, but with conditions, and since then nothing has changed as far as I'm concerned. Between 2003 and 2009, the mill was run as a popular and successful neighbourhood pub and restaurant by Paul and Chris Clark of Triple Rock, albeit with certain noise problems at the beginning. But they moved on, and since then the pub has been operated by Butcombe. In recent times, I have to say that there have been problems, particularly with a couple of unsatisfactory landlords between 2016 and 2022, when the last one finally moved on, which has made our lives as near neighbours pretty unpleasant, to say the least. I'm the closest neighbour. When the new tenants took over just a year ago, we were optimistic that at last the mill had turned a corner and that once again it would be a friendly neighbourhood pub stroke restaurant. Now we learn that they wish to run it as an events venue as well as a pub, by extending the hours for the playing of music, both live and recorded, and increasing the number of outdoor events from 3 to 10 per annum, and by removing the condition of having at least 2 clear weekends before each outdoor event. They also wish to expand the external licensed area to not be subject to conditions on outdoor events, and to include a large part of the car park as well as the island, also known as Little Rackham, which is subject to a Section 106 agreement that has been in place since 1992. In my view, licensing the external area is unnecessary and would be totally unacceptable, as it will create more disturbance, not just from noise nuisance, but also because there would be a need to increase the already intrusive and far from low-level lighting, which is left on every night long after the pub has closed. I strongly object to the idea of introducing an external bar and simply don't understand why it's necessary. Why not reinstate the cellar bar? I assume it's still there, or maybe it isn't, to not only serve those people outside and on the terrace or beyond, but also to reduce wait times inside when the pub is very busy.
My main objection is due to noise nuisance, though, in particular from external music. This is a peaceful riverside location with low ambient noise, and the music doesn't have to be particularly loud to be quite irritating, as sound carries due to the topography of the area and because there's a river which magnifies it. At times, this is particularly intrusive and adversely affects the peace and enjoyment of our own home and garden, and I am well aware that many other residents of Road are similarly affected. Whether the music is enjoyable or not is irrelevant. Whilst patrons of the mill can listen to as much or as little as they wish, they can leave when they've had enough. We can't. We have no choice. We have to listen to it whether we want to or not. We can't unlisten. External performance of music, whether live or recorded, is totally at odds with this quiet location and, in my opinion, is a serious nuisance. There's also noise from traffic, particularly when there are events, as most guests are from outside the area. Hence, taxis delivering and collecting their fares, travelling back and forth across the bridge, and due to its single carriageway, therefore frequently having to stop and start at each end, thus increasing the disturbance. And finally, noise from rowdy revellers at the end of the evening as they take their leave. Not all are, but it only takes a few loud voices and shouts to really cause a disturbance. We've lived here for 27 years, so are only too well aware that the disturbance that can occur if the pub is not properly run. However, I most sincerely hope that this won't be the case. But my concern is that if the current tenants do decide to move on to a new venture, perhaps, and Buckham has been granted this variation as requested, we have no guarantee as to who might follow. Regrettably, based on recent experience, this does not bode well. I also have concerns regarding public safety and environmental harm, but we'll leave those subjects for others to speak about. There's plenty more I could say here, but I appreciate that time is short. So finally, the mill is a pub/restaurant and is a great asset in this rural village. However, it should not be allowed to become an events venue. As was made clear in 2005, I attended that hearing myself, this is not a suitable location for such an enterprise. Since then, nothing has occurred to make me change my mind, quite the reverse, in fact. Having read the overview of representations, including those from the police and environmental protection, it is clear that they and many residents of Road share my concerns and that therefore this application should be refused. Thank you.
Thank you very much. I believe next we meant to have David Jupp, but Grant Slade is going to speak on his behalf.
I don't know if the chair wants to read it.
To be honest, we've got a lot of written submissions already, and we don't really wish to.
If it helps, I'm happy for you to read it when you retire to foreshorten the hearing. Up to you, Chair.
If Mr. Slade wants to read it, I cannot stop him. So carry on, Mr. Slade. Do you want to sit at the microphone?
I'm sure many have covered all the concerns that I have in my absence. My family occupied part of the mill before it became a pub, and it really was never suited to being one. The application should not be approved to allow it to be an outside events venue. It was given permission to be converted to a pub in the early 90s, and as part of that permission, certain restrictions were imposed, including the 106 agreement. This area must be protected for so many environmental and safety reasons and should not be licensed. In fact, neither should the car park and the other outside areas. The whole village can hear music from the mill, and extending these hours will be disastrous for this quiet rural community. This is a small country village in a conservation area and must be protected, as should the listed building that is the mill building itself. I did read a reference from the application about low-level lighting. I would like to point out that the mill now has lights mounted up in trees and high-level floodlights around the outside walls of the building. These are not low-level at all. There are, however, no lights on the island where the applicant wants to use for events. Before the conditions imposed in 2005, the events and other activities caused a great deal of nuisance and disturbance in the village. It was because of this that the council put all of these current conditions in place to promote the prevention of public nuisance. The council saw it fit to impose all these conditions back then, and nothing has changed. The new owners at the mill have said they want to run the village days at the pub, but these village days are the lifeblood of the village charities like the Playing Field Committee and Village Hall, as they make their biggest amounts of money from the food and drink sales at the playing field events. Coronation Day was a rare instance when the playing field couldn't host it this year. The village organisations do not need these vital funds taken away from them, as they will not survive without them. I ask the committee to reject the application.
Thank you, Mr. Slade. Nigel Hellier.
Okay. Well, Mr. Chairman, I started by writing good morning. It seems optimistic, but there you are. So I'll start again and say good afternoon. I'll be brief, but I just want to make some points that support our written objections. Much has been made of the impact of the neighbours on this application from Buckham. Our property is only 350 metres from the mill, but we were unaware of the application process. Like Jill and Priscilla, there seems to be an occurring theme where we've had some really poor communications from Somerset Council. What processes and procedures have you got in place that you're actually following to ensure that local residents were made aware of this? In addition to that, there was a meeting down at the mill. I didn't even know about it until after it had been held, and my wife and I would have liked to attend. And I've got to say, guys, I don't think it's on. I think that there's been some short notice periods with the original meeting, and that was generated by Buckham. But I don't think Somerset Council should be led by the nose by that. They should be saying no and actually giving people time to attend. Our property backs onto Barrow Farm, which is at the Bensons. The distance and topography of the land means that the sound from the mill travels into our garden and house. When there's a live event, we are able to hear all the live events played on by the mill. The external events drown out our domestic music from our kitchen. We've got a little iPod speaker there, and we just have to turn it off. We can't hear. Like Priscilla, we have to listen to the mill's music above our own, whether we like it or not. And that's not whether we like the music or not. We just have to listen to it. We can also hear people eating, drinking, shouting from there. But that's, at the moment, there's three outside events a year. And hey, they were there when we bought the house, so we kind of live with it. But be cognizant of the fact, please, that these noise levels can be very, very intrusive. I'd also like to draw the committee's attention to Avon Somerset Police objections. They clearly point out the deficiencies and irresponsible behaviour that's been endured under, I hate to say it, Buckham's tenancy over the last few years. And I don't think we need to go into that we've discussed the drugs thing at length. But I do question what would happen going forward with this premises licence holder. My wife and I are firmly against removing any of the existing licence conditions as we've previously submitted, because there will be a detrimental effect on the quality of our life in terms of noise, levels, hours of noise, direction of the music, number of traffic movements. For us, responsibility is a key theme attached to the sale of alcohol. As we all know, behaviours tend to deteriorate when alcohol is consumed. Along with this, individuals' noise levels increase as their inhibitions recede during an evening or day's revelry. This will happen at any type of function, be it a wedding or a wake, and we all know what can happen with alcohol. The current conditions were put in place for a reason, i.e. to manage the mill as a building, not you guys, in its rural setting and minimise its impacts on residents. There is a high likelihood that any changes to the licence could be abused in future, and that's our thoughts. Buckham Brewery acquired the lease to the mill with the existing licence conditions in place. The solicitor today mentioned the commercial need to change as times have changed. We understand that the mill is not a cheap establishment to run. However, Buckham knew what they were buying when they leased the property. If flawed business cases are in place and turnover needs to be increased to make the business viable, it is not for the residents of Road, nor Telesford, nor Wolverton to have to endure the consequences of poor management. As we've seen, there's been a set of conditions issued initially. There was some revised at the end of last week. Then we had a revised document issued just after the break, and then the police have come in and weighed in with their conditions as well, which, to be quite honest, I think most of us are grateful for. If I would like you to reject this submission, but if you're going to, and if you're so minded, then there needs to be a resubmission stating very clearly what this application is about. There's been so much change and there's so much of it has been discussed today. So I'm fully supportive of what Andy Pickett said earlier on. So that's all I've got to say. So if anyone has any questions, no, thank you very much.
Thank you, Mr. Hellier. And finally, we've got Grant Slade again.
Press the right button this time. You'll be pleased to know I've put a line through so much of this to avoid repetition. We had hoped to get a list of the speakers beforehand so we could at least know who's speaking and saying what to avoid repetition, but I understand we weren't allowed to see sight of it. Anyway, I've tried to get rid of as much, and I've also tried to take out bits that I now don't believe are relevant due to the changes that we've been discussing. I too am very confused, the same as a number of people. Anyway, I'm Grant Slade and I live 100 metres from the mill's boundary. My representation is Appendix 20, and I'm speaking for myself and my wife, the village school teacher, who also put in an application, representation. Our bedroom windows all face down to the mill, and we can see down onto their terrace. We can hear every time the pub have music or events, but we have taken some comfort in knowing that these sensible conditions that are currently in place protect us from there being too much music and too much nuisance. Sound travels out of that site and seems to go further and louder than you could ever imagine. 57 representations submitted by the public and responsible authorities is all that really should be said, isn't it? The mill has never meant to be a pub. Its location does not suit an outside events venue. Restrictions were placed on the mill by a previous licensing subcommittee, most for the prevention of public nuisance. We experienced noise and public nuisance under the previous DPS, which has been expanded on at length. But that was while stringent conditions were in place. So with fewer conditions, more activity, and varied times, which again, I'm confused now what they will be, things can surely only get worse. The applicant has said that the business isn't viable and needs to be changed to survive and to combat economic pressures and competition. However, TripAdvisor would suggest there are some other issues. If the business is struggling, get the basics right first. The variation is not a sudden decision to save this business. The application, we believe, has always been coming, but it should certainly not get approved at the expense of those long-established businesses next door or at the expense of neighbours' mental health or right to some sleep. So what are my issues? Much the same as everybody else. Primarily noise later into the night, the increased noise through the day, the increased traffic and public nuisance. Licensing the whole of the outside area, to me, seems insane. The applicant and DPS at the pre-meeting, the public meeting that we talked about earlier, said that they should be judged by their actions, or I think that's what Mr. Rowley said, that we should judge Buckham by their actions. He also told us that he would never have his tenants out of control. He could control them, and that he wouldn't overserve people, or his tenants wouldn't be overserving people. We then asked Sam a question, and he responded with admitting to a drink driver that he continued to serve knowingly, and even named him in front of 35 people, including the licensing officer at the time and others. That said, I worry that this application would lead to more events and less control. I object to the music being extended to at least 1 a.m, although whatever that time now is. I'd object to increasing the outside events from 3 to 10. I believe in the last year, the applicant has had 1 outside event. Just after this application was submitted, the mill had a band playing outside that finished around 10 p.m. I'm very sad and had gone to bed, but I could hear the music. At 10 p.m, a 10 p.m. finish is okay, I guess, but later into the night would be intolerable. I did a Facebook poll the next day to gather some data and see how far music had been heard. And the results of that came back as up to 1.4 kilometres. Appendix GS2 on page 106 will show you those results. And that doesn't show all of the results. There'd be too many lines. It was just trying to show the spread of sound and how it comes out of that location. We also worry, as others have said, that the current tenants can move on. The licence will stay with Buckham to allow another, maybe like the previous one, to do whatever they like, when they like, with no regard for anyone. I also have an issue with how this applicant has gone about the application. I raise this as some things don't seem to be in line with the council's own licensing policy that I believe Mr. Godley wrote. We only saw the site notice by accident. We asked for an extension. We were refused. Due to the objections, the licensing officer suggested a public meeting. I believe it was the licensing officer, not the applicant. At the public meeting, Buckham's area manager stated that we were not entitled to know anything. We didn't need to tell any of you any of this. And I only mention this as, having now read the council's statement on licensing policy, I note that section 4.1 premises licence contains the applicant should liaise with neighbours and community groups before applying, and also states the applicant should liaise with relevant authorities such as the police before an application. To my knowledge, Buckham nor the tenant did either. And I believe the tenant has said that Buckham asked them not to talk to any of the locals. In closing, the tenants told the chair of the parish council yesterday that what they actually wanted was very different from the Buckham application that had been submitted, and that wasn't what they wanted. In which case, reject this application completely. Let's have a new application that matches what the tenants would like, and perhaps with a bit of community input. We would all love to see a thriving pub there. The applicant and tenants knew exactly what they were taking on and the conditions that were in place. Economic pressures to me seem like just a convenient excuse. I bought a house next to a pub. Why did I do that? Mainly because it was next to a pub. But the pub has conditions imposed by a previous subcommittee that should make this a pleasant and safe place to continue living. Since those 2005 conditions were imposed, the sound travels in the same way, our houses are still in the same place, our businesses are still in the place doing the same thing, nothing has changed. I really do implore you to reject this entire application and let's see a reapplication. Thank you.
Thank you, Mr. Spade, and thank you to all the speakers. Have we got any questions of the other persons? Marcus?
That's all right. No, I think I'd like to thank all the speakers for coming and speaking, and all those who actually made representations. I made a few notes about what questions I'd ask. I would say most have been covered or have knowledge in, so it's not like I'm not, have nothing to ask, or not like, sorry, put that in a different way. It's not that I wasn't listening or haven't made notes and everything else, but I don't think there's any questions that I could ask that would actually clarify anything further, so I'll leave it at that. Thank you.
Thank you, Marcus. Hugh?
I thank all speakers, Chairman. You don't realise, but we're supposed to have another meeting now at 2 o'clock on pink papers. That's confidential. So we're in for another hiding ice back, but we'll see how we get on here. Thank you.
Thank you, Hugh. Does anybody else have any questions of the other persons? Jack?
Just on the list here, Councillor Mike Salmon and Anthony Battersby on the list.
So that was Andy Pickett was speaking on their behalf.
On both?
Yeah. Yes. I think written submissions, if we set the precedent of reading out one written submission, we'd have to read them all out. And as you know, there's 50, 53, 54 other ones. So we don't usually read out written submissions unless somebody from the public reads it for them. Thank you. Jack, any others? Applicant?
No, I don't have any questions. I have a few comments in summing up, which I'll deal with.
Okay, in that case, we'll move to the summing up. Yeah. Okay. So now we're going to move on to the summing up in the order I've got them down here. Does somebody wish to sum up for the other persons? I'm not looking at anybody in particular.
Thank you, Chair. I'll be as brief as possible. I don't intend to repeat the issues, repeat the detail, but simply to summarise it as this. There's clearly grave concern about this, not just because of what we see in the future, but because of what residents experienced in the past. These conditions were put in place and have successfully, and I commend your predecessors for doing it, they come up with some very successful conditions that have enabled the pub to run now successfully for 18 years, alongside the residents with very few complaints. And Mr. Benson made it put it very well earlier. The reason there are no complaints is because the conditions are working. These changes are wholesale and they go way beyond the picture that the applicants wish to paint. They simply don't need to license the whole of the outside area. They explain it as, we wish to be able to serve alcohol on the terrace. That is the beer garden equivalent that your licensing officer referred to as a conceptual inclusion. And if the licensing area needs to be extended to include the terrace, provided that it is only for the purpose of serving alcohol and it doesn't increase an area such that outdoor music could be played from it, there would be few objections from this quarter. But that's not the application that's been made. The application is to turn the entire site, which is quite extensive, you can see it on the plan, into a live venue location. That is of grave concern, as is the lack of consultation and the iterative process by which this application has landed where it has. It may well be, actually, that the correct interpretation of the various inputs render it quite a reasonable outcome. But if nobody knows what that outcome is, and if it can't be distilled, and this doesn't cover everything, this simply lists the conditions that would be applied. The red line clarification that I asked for hasn't been done. Have they removed the request to exclude outdoor events from being classed as outdoor as per the 4th bullet point under section C of their original application, for example? We just don't know. If you do wish to determine this application, good luck to you to determine what it is, and I hope you do a good job. And I hope that the outcome is something that we can understand, we can enforce, and we can live with. In my submission, it shouldn't be determined. It should go back to consultation. If you do determine it, then please do not extend the licensing area in the way that's requested. Do not extend the timings for music in the way that's requested. And certainly, please do not, as per the wording that your colleague raised, Mr. Chairman, in one of the early questions to the applicant of section C in the application, bullet point 4, which effectively renders all restrictions on the outdoor events null and void. It's essential that this application, if passed in whatever form it is, it makes sense and it factors in all the concerns you've heard from residents today. Thank you for that.
Thank you very much. Does anybody else wish to sum up of the other persons? Seems a bit impolite to call you other persons. Yes, sir.
It's really, I just want to add something which I think has been neglected, and that is the question of child safety. The proposed extension of the red line to encompass the island will in fact take it right the way up to the north end of Road Weir. I am the owner of Telesford Weir, and we have had deaths at Telesford Weir from people falling in the water. And I think that you need to be aware that that is an issue, quite apart from the fact that there are 2 watercourses, both of which are fast flowing. Thank you.
Thank you very much. Right, we'll now move on to responsible authorities to sum up. Please.
Thank you. I've just got a few notes that I've obviously just written down quickly just to refer to. So obviously you've had sight of the police objection, obviously outlines in detail the current position of the police with regards to the application. We've gone through that representation in some detail and I don't intend to refer to it any further. However, if you are minded to grant the variation, we would request that all conditions requested by the police are attached to Annex 2 of the premise licence to enable the promotion of the licence and objectives. As the majority of the proposed conditions have been agreed, I would ask you to consider the condition with reference to the external area and the times of operation. The Village of Road is a rural location with residential properties surrounding the premises. Experience suggests that when people become intoxicated, they can become very vocal, either by way of talking, laughing, shouting, generally having a good time. Whilst we do not wish to ruin people's enjoyment, we must consider the rural location of the premises. The police are of the opinion that anything beyond those hours proposed by the police will have a detrimental effect on the surrounding area, which can result in conflict affecting the prevention of crime and disorder objective. We would request that these proposed conditions apply at all times and any other similar reference currently on the licence is removed. For the avoidance of doubt, the condition with reference to no more than 10 event days, it would be our understanding that there would be no more than 10 separate events which last no longer than 24 hours. Thank you.
Thank you very much. The applicant is invited to sum up now. Sorry. Oh no, sorry, environmental health. Do you wish to say anything? You don't have to, but you can. He's withdrawn. No. Applicant.
Yes, thank you. I will try to be brief. I'm not going to repeat myself, or I hope not to do so. I have a couple of preliminary points which have been mentioned in the summing up. The first is some suggestion that the procedure was incorrectly followed. You will rely on your legal advisor in that, but let's be clear. The legal responsibility is to serve the application, and there is then 28 days consultation period. That's what it's referred to in the Act, in the regulations and the legislation. It has to be advertised at the site, which was done and has been checked by your officers quite correctly. More than one site notice. In addition, it's required to be advertised in the press. That has been done. So all of that's done. There is then no requirement for a meeting, residents' meeting, was suggested and was held. Quite difficult, particularly for the tenants to be faced by a large number of people, but they did that. So there was consultation. There is nothing further that should have been done. And in fact, there is an argument that if the licensing authority had done more, they step outside their obligations and go too far. So that's all I would say on that. The application has developed. We lodged it. We've taken on board comments. We've done the clarification document, all of which constricts, restricts, reduces the nature of the application. And the document that we now have today before us, with the very great help of licensing officers to produce, crystallises the changes. And that's key. And that is what we're talking about. We're talking about changes to the existing licence. The other legal point I make is twofold. Firstly, the Live Music Act came in 2012 and allows entertainment, live music, recorded music in certain circumstances. That is deregulated, not unregulated. You are not dealing with that today. That is there. We can do it. And we say we can do it outside already. And we can certainly do it inside as well. So we will comply with the law, but what we are talking about and what this application relates to is regulated entertainment, both inside and outside. So that's extremely important to deal with. The only other point on the law I would mention is there's been some reference to 2005 and the application coming before the committee. Well, of course, it did, and a decision was made. But the law does not say you can never come back and apply for more. And in fact, I was not involved, and none of my colleagues were involved. But if you utilise that and it doesn't cause an issue, then that perhaps shows you can use it and you can expand upon that responsibly, upholding the licensing objectives, which is the whole crux of what our application before you is, that we will continue to run these premises responsibly. And on that, there was a bit of history, and it was referenced over quite a long period. There were issues with a particular tenant. I'm not going to go back over that. My questions to the police were only to clarify that we felt we had done more than was being indicated. I'll say no more than that. There's been no indication of anything adverse in the last 15 months or whatever it is that client's been there, who's been able to operate on the existing authorisations for 3 events. And what this application is to go from 3 to 10. So we're not doing something massive. That's what we're saying. And in fact, with some of those events, we're actually constricting down the hours for the outside, because at the moment we have 3 to 23:30, and we're saying actually these family days, beer festivals, will stop at 2200. It's the ones in the marquee where we have referenced noise measures, conditions that we would like that flexibility for, so 5, 6, 7 times a year to go to midnight. And that's what we're asking externally. Internally, we're just asking to bring it in line, and I'm not going to go back over those hours. And the layout gives that flexibility on outside areas for bar serveries. So that's all I'll say on that. In relation to the representations, yes, you've heard from a number of residents. I would say, yes, you have had a number of residents made representations, 50 something, and there's a number here, but it is quite a large village over quite a large distance with quite a large population. And one of the people tried to say, well, we speak for the village. Now, I can't say I speak for the rest of the village that aren't going to make objection, but you have to have something positive if there's going to be an objection. So please bear that in mind. On the sorry, Chair, I was quiet when everybody was speaking, and I only ask for the same courtesy. On the geography of the village, I know 2 of you, I think, visited, and so I'm not going to talk about it, other than representations are from different parts of the village, and there are some that are considerably further away. And so I'd ask you to bear that in mind, and the physical nature, physical layout that you have seen, and I saw this morning, and in the plans, and how the layout works and what the plan shows. So that's why we that's why we believe we won't cause an issue. And there's been presentations about, well, what can't you build in something that guarantees there won't be? That's not how the law works. This legislation is permissive legislation. We promote the licensing objectives and we don't cause public nuisance or crime and disorder, threat to public safety, protection of children from harm, then we are allowed to operate. If we do, then there are means of intervention, escalated means of intervention, review, environmental health, noise abatement notices, antisocial behaviour. That won't happen. We say we're going to carry on as we are, a little bit more than we've been doing before, but operating responsibly. And so that's the basis of the application. The police, we had good dialogue with the police and explanation, and got to where we got to this morning. And there is only one point of difference between us, and the police confirmed in their submission, want those conditions, we're happy. I'll come back to the 30 minutes difference where we go from 23:30 to midnight. EHO, Environmental Health, you heard, I can say no more. He withdrew his representation on those agreed conditions. The document is clear. It is clear. If you read it, you can see exactly what we're asking for, and that's what the application should be considered on. Now, I need to refer to a case and then some of the guidance. So firstly, I'll refer to the guidance, and it's paragraph 9.12, and I'll read some of that out, and it's the position on responsible authorities. Each responsible authority will be an expert in their respective field, and in some cases it is likely that particular responsible authority will be the licensing's main source of advice in relation to particular licensing objective. For example, the police have a key role in managing the nighttime economy and should have a good working relationship with those operating in it, and the police usually be therefore considered for crime and disorder. Then says, but any responsible authority can make a representation. It doesn't, however, say, however, it remains incumbent on all responsible authorities to ensure that their representations can withstand the scrutiny to which they would be subject at a hearing. And I did ask some questions, and some of them were quite difficult, because the police are saying, on the midnight, this is the marquee events, if I call them that, pull that back to 23:30. But there is no evidence of crime and disorder at this site, which is already authorised to operate until 1 a.m. and can, as it stands, have people outside being served alcohol. That's there on the licence, and there's no evidence of existing crime and disorder. There's no statistics around the history, in fact. So I ask you to bear that in mind as to what the position is, because that paragraph of the guidance is extremely important. In relation to EHO, it's even simpler than that. They're going to be your prime source for prevention of public nuisance. No objection, withdrawn. Because of the modified application, I accept. As the application was lodged, it was bigger, it wanted greater flexibility. We reviewed the position. We've come to where we are at today. So that is it. And the responsibilities are there for you to consult, and the guidance tells you that, but it does have to come up to proof. I'm not going to go, I mentioned financial situation. I think I mentioned it once as a passing, but it's been thrown back 3 or 4 times. Yeah, it's important. I'm telling you, that's a fact of life. But this application's on the licensing objectives and promotion of those licensing objectives. And we say that those measures include and deal with that. And the last point I would make is just there is a case, and I did refer it to your legal advisor yesterday. You may have heard it. I have hard copies if you want to have hard copies, but you will probably know it. It's called Daniel Thwaites PLC v Wirral Borough Magistrates. And it was High Court decision. It went all the way up through the different roles. And it was slightly different to this, but it was a variation to extend the hours. And I think it was granted, refused, granted, and it went to the magistrates, and the magistrates refused it, and it went up to the High Court. And what that case said is you have to look for real evidence. And that's key, two words, real evidence, to make the basis on. In that case, parish council objected, and the councillors or the magistrates court listened, and they refused the application, and the judge, High Court judge, so senior, effectively, I'm paraphrasing, it said, fear is not enough. You have to have real evidence of a problem. And that was to an extent, what your legal advisor was referring to in the article. That's the case, and it's there. And in that one, it was an extension, and it was a question of how often would it be used if you extend, and that's perhaps more in relation to the interior, but even regulated entertainment. We're not increasing, we're not seeking to increase the number. It's 75, we're staying at 75. We're going from 3 to 10 outside, as we say. So that case is important. And I noted down a couple of things, comments in the past, and working well at it's working at the moment. It's a worry. You don't need it. Well, need is not relevant at all. The pub's a great asset. Comments like that, and then those parties that have spoken well. You will have seen that, and they are able to put forward their case. But equally, there is no record of any complaints on the Environmental Health Officer record. Not a single complaint about noise nuisance. There's no incidents of crime and disorder that have been noted. That is the question of real evidence. and fear is not enough. So when I talk about that case, that is extremely important. So when you return, because you are guided by the guidance, that paragraph 9.12 and the case law which interlink, there is lots of other references in the guidance. And then I'll just refer, I think it's from the report, but it's essentially page 15. And it's, I'll come back to page 15, but page 16 talks about the options available to you. Should the committee be mindful to attach conditions to the licence, they must only do so if they're appropriate, necessary, proportionate, and don't duplicate existing statutory requirements for offences. That is important as well. And then I think my very last point, just on your paragraph 7 on page 15, talks about Live Music Act. That is exactly on point. Live Music Act is not before you today. It is not within your concern. Deregulated entertainment goes back to where I started. You know, Buckham Brewery are a good company. They have not had action against them that I am aware of in relation to premises, how they operate or don't operate. They got rid of that previous tenant. It was difficult. It was difficult times, but they did it and they acted. There's no indication there's a problem here. And Sam Knight, nobody has said anything adverse about TAM. And those are the two parties that are before you in this application and how they will use it and the time and effort that's gone into the documents that are in the bundle prepared by Sam and the other things, and then the consultation. So that's where we get to today. I will pause. I apologise for holding you longer than I anticipated. Thank you.
Thank you very much. I'm sure we'll be bearing in mind the licensing objectives when we retire. Licensing officer, to sum up.
Yes, thank you, Chair. So just to clarify, this document that was created during the break and was circulated to everybody and both online, this is the latest condition or latest version of the proposed conditions. People refer to conditions in the original application. Those have all been integrated into this document now, including the timings at the bottom. The only slight changes that came about as the conversations carried on after the break is that condition 6 is to include that the music live recorded music would terminate on occasions at 2300 on Sundays, as that came up. Sorry, 2300. And then condition 8 is that the regular patrols would take place during any external and internal regulated entertainment events. Okay. The event days, sorry. Yeah.
Sorry, we're not taking questions now. We're just summing up.
Okay.
No, that was included in what was being said.
Okay, so going back to the report, the decision-making process. The subcommittee must consider this application on its own merits and the information contained within the application and this report. Members are reminded that the duty of the licensing authority is to take steps necessary to promote the licensing objectives in the interest of the wider community. The licensing objectives are as follows: the prevention of crime and disorder, public safety, prevention of public nuisance, and the protection of children from harm. In its decision-making process, the licensing subcommittee must have regard to the Licensing Act 2003 and subsequent amendments, the statutory guidance issued under Section 182 of the Licensing Act 2003, Somerset Council's statement of licensing policy, and the policy is available on request or on the council's website. And the options available to this committee are as follows: grant the variation with no modifications and only attach conditions as required by the 2003 Act. These shall include mandatory conditions and conditions consistent with the operating schedule. Grant the variation modified to such an extent as the licensing authority considers appropriate for the promotion of the licensing objectives, or refuse the variation, giving reasons for its decision. Should the committee be mindful to attach conditions to the licence, they must only do so if they are appropriate, necessary and proportionate, precise, clear and unambiguous, practical, realistic and enforceable, non-duplicative of existing statutory requirements or offences, modern and fit for purpose, and consideration must also be given to the number of conditions being attached. The licensing authority recognises that most licence holders seek to follow the law, and any enforcement action will normally follow a graduated approach. and in the first instance, it will include education and support. Where licence holders continue to flout the law or act irresponsibly, firm action will be taken. Right of appeal. All relevant parties to decision of the licensing authority have the right of appeal to magistrates' courts in relation with this matter. This must be done within 21 days of being notified in writing of the relevant decision. Thank you, Chair.
Thank you very much. Right. We're now going to close the meeting and retire to make a decision. Normally, we try and give you a decision the same day. However, this is quite a complex application, and therefore I will say that we will make a decision and you will receive an answer in writing within 5 working days, together with the details of the right to appeal.
Yes,
Leslie.
correct, Chair. That provision is contained with the Licensing Act 2003 hearing regulations, which provide that in a fairly complex application before the committee such as this, we can get our written decision to everybody within 5 working days. And it's only when you receive that written notice that the appeal period starts.
Thank you very much. Thank you all for attending today. It's been an interesting day. But thank you all for coming. Thank you all for your input. And as I said, we'll retire to make a decision and let you all know within 5 working days. Thank you for your time.